Can I just say something about Andrea?
Well, hello, everyone. What a surprise! What a surprise to see you guys back here to talk about the Bryan Kohberger case. Gotta tell you, I did not see this one coming. Really didn't. I mean, it's not impossible. Obviously not impossible. Here it is happening. But yeah, I just have so many thoughts. So many thoughts about this new development. Oh, of course, you guys, you know what the new development is. It's this right here. I don't know how well you can see it, but this is the, I'll make it bigger. This is the Odyssey entry for the post-conviction petition filed by Bryan Kohberger. So this has got all the case information. You can see this hit the court docket yesterday. It's got, here's the case number associated with it. You'll notice this is a civil case number. It is filed separately under a different cause. This is not considered a continuation of his original underlying criminal case. It is a separate civil process. We are going to talk all about how all this stuff works and what it means. So here he is, the petitioner, and here is what has been filed so far. The case entries on it, information sheet, the petition, motion and affidavit in support of appointment of counsel, and a motion for permission to proceed on partial payment of court fees. And that is what is on the docket as we sit here today. So I've got the documents. I was able to get them from the Ada County Court. I think a big question I have, and I'm sure lots of others are going to have as well, is are they going to do the thing like they did with the trial case where they put it up on the cases of interest page and then posted all of the documents for everybody to see? Or are we going to have to like go in and continue to monitor this and go through the Public Records Act, basically, process to get copies of them? Because they don't have a portal, a way to directly access documents digitally online. So you gotta contact the courts, pay them their money, and then you get the copies. So I did that for this particular one, but of course I very much interested in finding out if that's going to be modified in the coming days. But since I have them, yep, I'm going to share them with you as well. So just to kind of give you a broad outline of where we're going to go here. Because I have so much to say. And again, just the likelihood of being able to get through all of this in one stream is, all of my thoughts anyway, is probably pretty low. But what I want to do is give you at least an overview of what this process looks like, what all of this means, and some of the kind of obvious next step things that are likely to happen, the implications of this, and how it can play out. So we got to start with the petition itself. Very, very important. This is what is setting forth his basis for relief. So it's clearly a pre-made form, a standard form for the state that he has completed. Now, an important thing that is here on this page is these two things right here. Date of the filing, July 27, 2026. Date of the sentence, July 23rd, 2025. Let me tell you why this is important right off the bat. Because there are time limits for seeking this type of relief, both in state court and in federal court. We're going to be looking at the state statutes for this process to help you kind of walk through what it looks like and what it all means. But I just want you to tuck away these dates in your mind because they are important and they may affect his ability to further pursue these claims in federal court. That's why the dates are particularly significant. So we, by and large, just have a form that is accurately filled out. He did plead guilty. He did not appeal. That is also very important. He did not appeal from the judgment of conviction or the imposition of sentence. And we know that. We'll walk through his plea waiver as well, and the implications of that. So this is the part that I am most interested in. What's he alleging? What's his grounds? Ineffective assistance of counsel during criminal proceedings is argument number one. And then secondarily, that his plea was not knowingly or voluntarily entered because it was induced by unkept promises. And then the third one, the plea was not voluntarily entered because of threats asserted by petitioner's legal counsel. Well, this is about as direct as you can get in a petition like this that is going to be blaming the defense attorney. Blaming the defense attorney. Not just ineffective assistance, messed up, was negligent, whatever. Coerced, threatened to induce the plea. That's a big claim, guys. That's a big claim. So then it goes on to ask specifically and in detail, what did counsel fail to do in representing your interests? And he cites failure to disclose or review exculpatory evidence, i.e. unknown hair in Chapin's hand during plea discussions. So this is a failure to investigate, possibly misinformation, failure to disclose to the defendant in the course of evaluating the choice between, do you plead guilty or do you go forward to trial? Second, counsel's insistence that petitioner's plea need not be truthful, despite petitioner's vehement denial of actual guilt. And then C, promises made by counsel regarding, this is LWAP, but I think it means LWAP, life without parole status, i.e. immediate contact visits, freedom of movement, employment, and elaborate lies of death row life. Elaborate lies of death row life. Now, gotta point out, this asks for detail. In detail. What happened? What are the problematic things that occurred here? And the reason why that matters is because there's a strong presumption against conclusory statements by a petitioner in this type of context. And this is a little bit of the double standard that you sometimes get in criminal cases where testimony is evidence. The defendant's testimony is just as valid evidence as anybody else's testimony, legally speaking. But courts are inclined to look at the defendant's evidence as self-serving. So they want details. They don't want just the conclusion, this was erroneous. They want to know real specifically, okay, what were you told? What were you told? What did you do with that information? How did this create a problem? There is a fair amount of specificity on the first claim, unknown hair in Chapin's hand. Okay, so we have a specific point, a specific item that we can look at to evaluate whether we have a problem here. And then second, insistence that the plea need not be truthful, despite petitioner's vehement denial of actual guilt. So we have a very specific representation that is being alleged. The last one is a little bit less specific. Promises made by counsel regarding status. We have a little bit of specificity as far as the content of what these things were about, like what the subject matter was, but not a whole lot of detail about exactly what was said. So this one, not quite the same level of specificity as the others. He's proceeding in forma pauperis. He is requesting appointment of counsel. He specifically wants to withdraw his guilty plea. And that is the petition. We then have his affidavit of facts supporting the post-conviction petition. So this is the opportunity to get into a little bit more detail about exactly what the problem is. This document has been out there. It was shared pretty early on in the publicity around all of this. So it is hereby declared that during attorney-client discussions, most of which included all members of Bryan C. Kohberger's immediate family, petitioner was convinced to falsely confess to capital murder and felony burglary by coercion, disinformation, false promises, and the withholding of exculpatory discovery. The following is material to the inception of the plea. 1. Counsel's failure to inform petitioner of exculpatory discovery received during plea discussions, namely, clumps of unknown hair found in Ethan Chapin's hands, as well as a failure of further inquiry. 2. Petitioner was convinced that actual guilt was not an important factor in considering plea acceptance. Death row was imminent, and, advised to lie, petitioner was to gain a, quote, legal victory, unquote, in entering a false plea. 3. A gross misrepresentation of and promises regarding what a life sentence would immediately afford petitioner, and a gross misrepresentation of death row in Idaho, including an elaborate, fabricated story of counsel's horrific experience touring an actual 8x8 death row cell, all communicated to petitioner and his family, allegedly by IDOC through counsel, thus constituting threats and promises made to induce a plea agreement. That is certified under penalty of perjury, and then there's his envelope, and that is what we have for the petition. I'm going to keep it here because we may be coming back to this, but I'm just going to show you also just very quickly so you can see what these are. There's this motion in affidavit for permission to proceed on partial payment of the court fees. This is just, he's alleging it's his first petition. He doesn't have money to be able to do it. Here's his inmate, his statement of his assets and so forth. He has nothing. He's in prison except for what is in his inmate trust fund, his commissary fund. Otherwise, doesn't have anything available. Personal references, he's using his mom and his dad as personal references. This then has supported with it basically the printout of his commissary fund, his inmate trust fund from the Idaho Department of Corrections from the time that he was first brought there, July 26, 2025. Up to the present day. Yes, this has also gotten some attention because there are lots of people who have donated to his commissary fund. But by and large, most common contributor was Bryan's mother. But so this basically is showing, it's to bring up to date, 177.03 is the current balance that he has in his inmate fund. Therefore, he has no money available. We then have the motion and affidavit in support for appointment of counsel. There were 2 entries for this. The reason why is because there were 2 versions written and filed. You can see, look at the fourth. The fourth is different. This is just a duplicate form. He filled it out twice, sent it in and filed it. And so they simply filed both of them. And it, again, just attestation. He doesn't have any money, can't afford to pay for it. And therefore, wants to have counsel appointed to represent him. So you can see it's just the same thing. Those are our documents. I'm going to keep that part handy because we may be revisiting it. So the next thing we're going to do formally is we're going to walk through the statute, the post-conviction process, and what it means, what happens, how does all this work, what the standards are, and stuff like that. But I do want to start with the far more subjective kind of element of a filing like this. Because I have always worn on my sleeve, guys, I was a defense attorney for almost 20 years. That's my perspective. That's how I worked cases. That's my background. That's what I understand. That's the experience that is always going to color my perception of what I see. I don't believe that it's really possible to eliminate bias. That is a fool's errand. We are human beings, and so I think it's just always been important to kind of lean into that fact that is where I come from. You know, prosecutors with a different background and different experience are going to look at filings like this and have a different reaction to it than I am for different reasons. But so I do want to share my knee-jerk reaction with you guys. And where it really, I think, came out for me was I was talking to Jeff last night about this petition, and he had seen it by then, I had seen it by then. And Jeff asked me, wow, having read this now, does this reopen questions for you about whether Bryan Kohberger is guilty or innocent? And the answer for me was this does change my perspective. It does. It does. Not in like a definitive I know something about this that changes my perspective on the underlying merits, but because it has to go against a backdrop of experience with claims like this and experience with people who make claims like this. And so it may not shock you then to hear that I take a very dim view of these kinds of allegations. Very dim view. Not that they're never true, can't be true in this instance, or anything like that. But it's just that when you have experienced situations where you have a defendant, the evidence against them is unquestionably going to get them convicted at trial. No way around it. But you still are dealing with just a massive amount of denial. Massive amount of denial. We'll never admit it. I've told the story before about the guy literally on video committing the crime, and we're sitting in the jail watching the video of the guy committing the crime. And we can both see with our own eyes, and he's still insisting, oh, that's not me. That doesn't even look like me. He's got the exact same like tattoo as the guy. It's freaking the guy. But that can be what it's like to deal with some kinds of criminal defendants. And so often I've described the job as a defense attorney, particularly with this type of context in mind, as the compassionate engagement of denial. That's really what you're doing. You are trying to not hold that against the person, not judge the person, not think badly about the person, but try to get them to understand what is in their best interests based on your experience as attorney, your review of the evidence, your prediction of what a jury is likely going to do. I would never put this in terms of what I personally think about a case. Do I personally think a person is innocent or guilty or whatever? Never talk about that with clients. It's just, number one, a bad idea because you have to be completely honest. And if you're not completely honest, that's a whole other problem. But often if you are, then you're going to have a breach of trust, right? If I think you did it and I tell you I think you did it, then they're just instantly going to be like, well, then you can't do the job. But what I will always talk with clients about, what I would always talk with clients about is, how's the jury going to process this information, and what's going to be the likely outcome of it? So what I think doesn't matter at all. It's completely irrelevant. But what's a jury going to do with this? And that's important because it goes to the reason why you're having plea conversations in the first place is cost-benefit analysis. What are the trade-offs here? What's the risk of going to trial versus the benefit of going to trial? And how is that going to play out given the facts that we have to deal with in this particular situation? And then based on that, what's going to be in your best interest? I can't make that decision for them. I can say it looks highly likely to me that you're going to get convicted, and if you do, you're going to face a real serious sentence. But I can't tell you that trade-off means it's worth it for you to plead guilty. That's up to you to make a decision about the trade-offs that you're willing to take or not. I'm like getting so far afield right now, but I think this is very important because I want to be very upfront about my knee-jerk reaction to a petition like this. So obviously I'm talking in hypothetical. I didn't represent Bryan. I don't know Bryan. I don't know anything about the conversations they've had. For a long period of this case, particularly in light of the lack of transparency that we had, all of the things that were filed under seal, some of which are still under seal, but a lot of which have subsequently become unsealed and have, shed a lot more light on certain things. The initial evidence to me appeared to be quite thin. Not zero. Yeah, probably enough for probable cause, but proof beyond a reasonable doubt, really not clear. And it was also pretty clear, I think, at the outset that the defense felt the same way. Pointed out very specifically in early pleading about the subsequent investigation, the lack of any connection with the victims, the lack of any trace evidence found in his vehicle that would associate him with the crime, no DNA, nothing like that. These are things you would normally expect to see. Things when you normally expect to see when you have somebody that's guilty, you expect to start to uncover lots of corroborating evidence of guilt. And that wasn't happening in this case. But there was a point where I feel like the calculus changed quite a bit. And that was when we had the motions in limine right before trial. This was in early 2025, February, March 2025 type of time frame. And that was the first point where came out that it seems that there was in fact a connection between Bryan Kohberger having purchased a K-bar knife from Amazon. Why was this such a game changer? Well, because in and of itself, trace amount of DNA on the knife sheath has potential innocent explanations, right? Transfer DNA is viable. And so that is that's a factor that is going to affect the weight that a jury is going to give that evidence. If it's potentially consistent with innocence, it's going to get weighted a lot lower than if it's really strongly corroborative of guilt. Do you guys understand what I mean by that? Somebody is on video committing the crime, right? Me and the guy are like sitting in the jail watching the video of him committing the crime. Okay. If you're thinking to yourself, I want to evaluate what's the probability that this guy is guilty. I have to look at like how strong does this evidence support an inference of guilt versus how strongly does this evidence support an inference of innocence. Very hard to support an inference of innocence with the guy is on video and we can see with our own eyes it's him doing it. Okay, maybe we have issues with authentication. Maybe we have, a possibility of being AI generated or something like that. It's not non-zero, but probably not high, especially not if I don't have any evidence of things like that. I can't point to problems with metadata or collection or something like that. Piece of DNA on a portable object where there's also like apparently other DNA. Yeah, it's you'd expect that certainly if somebody is guilty, if this is the murder weapon, you'd expect probably their DNA, the murderer's DNA is going to be on this thing. But it's not also that implausible that the non-murderer's DNA would be on it, because it's portable and transfer DNA really is the thing, and stuff like that can happen, has happened historically. But that changes a lot in my mind when you have proof that he actually had a connection with a K-bar knife and doesn't seem to have that K-bar knife to produce at trial to be like, here's mine, here's how I can show you. It's not the same thing as the one that was found at the crime scene. Tends to make it more probable, in my view, that the knife sheath at the crime scene is his versus that his DNA just coincidentally happened to end up on two separate, otherwise identical knife sheaths. So my view that evolution in early 2025, that information was like, oh, that kind of changes the dynamic, I think, about trial and the prospects of trial. I offer this all by way of background, again, to just try to be as transparent as I can about my perspective on this case and my gut reactions to things. Because as I said, this does not sit well to me. It doesn't sit well with me. I've had clients that we walked through these conversations and we've gone through the denial and we've worked out, what's in your best interest and so forth. And then they turn around and file something like this that is not a particularly accurate representation of the truth. I'm not saying that's what this is. I want to be very clear. I'm not saying that's what this is. I don't know that that's what it is. I just am telling you, that's going to be my immediate association. Okay, that's going to be my vibe. But besides just my personal reaction to it, which is important for, purposes of you guys being able to decide how much weight you want to give my analysis or not, I think it would be remiss to not suggest that that's not unique to me. The court is going to take a dim view of this as well. Courts take a dim view of these types of claims. My lawyer lied to me about XYZ. My lawyer coerced me to take the plea. This is not the first time the courts have heard accusations like this. They're very, very skeptical of them. So I do think that is important to bear in mind. Having gotten all of that out of the way. Doesn't mean this isn't true, doesn't mean this doesn't warrant further proceeding, further investigation, and so forth. So with that, let's go ahead and turn to what the process is going to look like, because there are so many like decision trees along the way of what could happen here that will affect how much of this gets fleshed out. Does any of it get fleshed out? Do we hear from Ann Taylor, etc.? So now we are going to turn to, we are going to turn, there's going to be a few statutes here to go through. I am using Justia because it is the easiest one to be able to just kind of scroll to the next statute, because there are a few. This is the Uniform Post-Conviction Procedure Act that Idaho follows. And so it sets out what possible claims you can make. It's in violation of the Constitution of the U.S. Court was without jurisdiction to impose sentence. Sentence exceeds the maximum authorized by law. There exists evidence of material facts not previously presented and heard that requires vacation of the conviction or sentence in the interest of justice. The sentence has expired and he's otherwise, there's some kind of unlawful restraint. Actual innocence subject to these other proceedings. It's subject to some other type of collateral attack that was available at common law. This is like preserving common law things like a writ of error, coram nobis, and stuff like that. And that's basically it. This is not a substitute for, nor does it affect any other remedy or an appeal or anything like that. Any issue which could have been raised on direct appeal but was not is forfeited, may not be considered in post-conviction proceedings unless it appears that it raises a substantial doubt about the reliability of the finding of guilt and could not have been presented earlier. What we are dealing with here is this one. Conviction or sentence was in violation of the Constitution of the United States. It's ineffective assistance of counsel is the argument that is being made. This is not newly discovered evidence. It's not the basis that is pleaded here. It is also not actual innocence. And we'll turn to this next statute why and talk about why. You guys may have seen there was a statement that Bryan Kohberger gave to the New York Times that has been published as well. I don't think I have that. I don't think I have it right here, but I bring it up because he does talk about his actual innocence, is why he's, continuing to do this. But it's important to distinguish what he's saying in the press versus what he filed in his petition. And so what he filed in his petition is not going to satisfy this option for post-conviction relief of actual innocence. And so we'll turn to the next statute and we'll talk about why. So you start it by filing the application. That's what he's done. And an application may be filed at any time within 1 year from the expiration of the time for appeal, or from the determination of appeal, or from a determination of a proceeding following an appeal, whichever is later. I told you guys, remember those dates. Sentenced on July 27th of 2025, or July 23rd of 2025. Filed his petition on July 27th of 2025. This is important because it fits within this time frame here, right? He has 30 days to appeal from the time he's sentenced. So that would have been, he's sentenced on July 23rd of 2025. That means his time to appeal would be August 22nd of 2025. So it's 1 year from that is his deadline. July 27th, it's within that deadline. The reason why I bring this up is because it's not clear that this is going to satisfy the federal standard for being able to file a post-conviction petition because they don't use the same deadline. In the federal system, the deadline is very strict. 1 year from the time the judgment and sentence becomes final. When does a judgment and sentence become final? If you don't appeal, then the day you were sentenced is the day it becomes final. If you do appeal, then it's typically what they're describing here. It's when your appeal became final, or if your appeal requires like a remand and further proceedings or something like that, a resentencing, then it's after that's done. Bryan didn't appeal. Under the federal calculation, then, his deadline to file a petition for habeas corpus would be July 23rd of 2026. This isn't timely for that. There are all kinds of complications and convolutions with just the procedures for post-conviction relief. I would love to have Michael Osbrook here because he's super expert on a lot of this stuff. And I am very much certainly not at the federal level. And so I don't know if there are arguments to be made such as like, well, but when did he put it in the mail? There's like a mailbox rule that sometimes gets applied for when do we determine a filing was like actually filed? Is it when it lands in the court, or is it when he put it in the mailbox? And that can be really important because he doesn't necessarily have control over when his actual envelope gets delivered to the U.S. Postal Service. He's got to give it to the legal mail people in the prison. They go through whatever process they go through with it, and they put it in the outgoing mail. So he doesn't have control over how long it sits with them before it goes out. That can be very unfair. My understanding, with the full caveat that I could be wrong about this, but I'm pretty sure I remember, they don't follow the mailbox rule. Not 100% confident, but fairly sure. So that would be an issue. Now, another thing that comes up in the federal context is that you have to typically exhaust your remedies in state court before you can bring things up in federal court. So that means if you have a process like this, a post-conviction petition that's available in state court, you typically have to try that before you can ask the federal court to give you relief based on the same arguments. When you do that and your petition in the state court is pending, then that time doesn't count against you. The time that the state court is taking to decide whether we've got a valid basis to withdraw his guilty plea here doesn't count against him for purposes of calculating is a federal petition timely or not. It's called tolling. So it tolls the running of the statute of limitations under the federal rules. But the problem is yeah, okay, that tolls, but it doesn't defeat the fact that it was filed already potentially after the federal deadline expired. So all of this is to say that this could be an issue in terms of follow-up. Not crystal clear to me that this is set up in a way that would allow it to get processed through the state court, and then if the state court denies relief, take it up to federal court to ask them to evaluate it independently. Not impossible. There's other arguments that can be made to get around the federal deadline. Equitable tolling is one. It's hard to get, but not impossible. And that will come up in situations where maybe you didn't discover the critical information until after you were sentenced. That might be available here. We don't know. There's not really enough facts to say, when did you find out about any of this that these things were misrepresentations that you're saying. The clump of hair, the evidence that you didn't know about. When did you learn about it? Possible that those could be avenues into federal court, but just notice right off the bat, it's at the very least going to be more complicated to take it to the next step than it would have been had this been filed well in advance of July 23rd. This is the actual innocence provision. This is the one that if we go back and go back real quick. Right? Subject to the provisions of 4902B through G, that he's actually innocent. So that's what we're going to look at next, B through G. B, he can file a petition to get DNA testing. If it was, your conviction was based on DNA testing, but there is new testing available that was not available at the time of trial, you can move to have that new technology applied to the evidence that led to your conviction in the case. There are some limits to that. You have to make this prima facie case. Identity was an issue. We definitely have that. No question there was a murder here. The whole issue was always who did it. So identity was an issue in the trial. There's a sufficient chain of custody of the evidence. We know that there were complaints about like the security of the crime scene and stuff like that, but just in terms of once the evidence was collected by law enforcement, there's nothing that indicates there's a problem with the chain of custody after that point. So it's probably going to satisfy that. It has the potential to produce new non-cumulative evidence that would show it is more probable than not that the petitioner is innocent. It would likely to produce admissible results under the Idaho Rules of Evidence, just basically meaning essentially the testing is scientifically, likely to be admissible. If it demonstrates in light of all admissible evidence that the petitioner is not the person who committed the offense, then the court shall order the appropriate relief. So that is B through F. That is what the petition could have been doing if it were an actual innocence claim. And to present an actual innocence claim, that's what it would need to do. It doesn't. It doesn't. So that's not an issue at this point. Where did my cursor? Okay, there it is. Moving on to the next one. Okay, this is just kind of procedural. They're going to compile the court file and look at everything and so forth. Basically, the basic records and affidavits and so forth need to be provided. That's all in their form. Costs, we already know about this. If you're not able to pay, then you can file a request. This is the part that's important. A court-appointed attorney may be made available to the applicant in the preparation of the application. So we know obviously Bryan has filed a motion and affidavit. He's asking for an attorney to be appointed. But the statute doesn't say he has to get one. It doesn't say he's entitled to get one. It doesn't say no matter what he gets one. It says he might, he may, the court can. So what does that mean? Well, what that typically means is that there is some kind of screening process that the petition is subjected to decide, does it merit having an attorney getting involved, or is it facially frivolous? In Idaho, there's like, I want to be clear. These are like massive bodies of law and like lots of decisions and lots of, as I've said, kind of different decision points and things like that. I have not exhaustively researched Utah post-conviction or Idaho post-conviction law. I've done a little bit of very, very surface level reviewing of some basic things. But this was a question that I was particularly interested in. And so I did go in and look at some cases, and the takeaway is basically what they're looking at is, does this state any plausible grounds for relief? Is there any interpretation of this that would plausibly support finding that he should be able to withdraw his guilty plea? Not like weighing the evidence or anything like that, because there isn't. There's literally just his affidavit. We don't have a weighing position from the state at this point. Typically, appointment of counsel is going to be decided before, like independently. It's not going to wait for the state's response. It's not going to take into account the state's response, because it is just based on the merits of this claim on its face. This is a really, really, really important decision point in the case, because if counsel is appointed, then counsel can go in and flesh these out. So to the extent, okay, we need more detail, he's referenced witnesses, his family could be witnesses to this. Ann Taylor is obviously a witness to this. There's discovery, that talks about what was known vis-a-vis what was in Ethan's hand, etc. They can go and like compile all that and then flesh out this petition to make it stronger. If the court does not do that, does not appoint counsel, then this is what we have, and this is what we'll be dealing with. Part of the reason why counsel being appointed is an extremely important fork in the road vis-a-vis petitions like this has to do with the feasibility of getting information, getting Ann Taylor's version of events at this stage. I, of course, don't know Ann either. Don't know her. My opinion of Ann is largely based on my knowledge of her history and how I saw her conduct this case. She seems to be more or less in the true believer camp for criminal defense attorneys. Not in the sense of, oh, everybody's innocent and everything's always a, police conspiracy or something like that. That's not really what I mean. I just mean that she chose to do this work for a reason. She had every opportunity to do other things. She chose to come back to public defense and to do public defense. Watching just in court how she interacted with Bryan, the representations, that she made about the defense work and things like that. I get the impression she's a very solid defense lawyer. And so because of that, I think the chances of her voluntarily providing a statement to the state are slim to none. Slim to none. Let's talk about this. First off, let me back up a little bit, because here I am talking about Ann Taylor making statements about plea negotiations. Classic attorney-client privilege. Classic attorney-client privilege. Okay, you don't get to disclose that stuff. Washington's is even broader. Washington's is so broad, it's client secrets, basically extends to any information, non-public information that you come into possession of by virtue of your representation of a client. Very broad in Washington. Idaho, at a bare minimum, we're talking about Did she lie to him in plea discussions? Did she tell him things? Did she tell him it doesn't matter if it's true or not true? That's what he's saying happened. Classic attorney-client privilege, but the problem is when you file a petition like this, you've put them at issue and you've now waived it. You've now waived it. One of the reasons, big, bright lights, sirens everywhere, major red flags with a petition like this. This is not in your self-interest, probably 99% of the time, because you've waived your privilege. And so what that means is that if this gets a hearing, almost unquestionably, Ann Taylor is going to be put on the stand and she's going to be asked about these conversations. She's going to be asked about why the guilty plea, how the guilty plea, what recommendations were made vis-a-vis the guilty plea. This is going to go very deep. It has the potential anyway to go very deep into things that are otherwise completely off limits. Conversations we had about that cost-benefit analysis that we just talked about. What he said in response. Rarely is it a good idea to open up this door. Now, if Ann Taylor is the defense attorney that I think she is, like I said, the fact that this on its face already has kind of waived attorney-client privilege, it's put it at issue in a public filing. Were she to give a statement to the state, it's probably not going to be a problem. Not going to get in trouble over that. There's a waiver. But she's not going to do it voluntarily, because you just don't do that as a defense lawyer. It's like the core of what your job is to keep their confidences confidential. This is just like so hardwired and ingrained, and certainly with the state. No, not going to volunteer it. State, you want to know what I have to say about it? Subpoena me. Get me under compulsion in court. And then we'll see. But it's different with defense counsel. It's different with defense counsel. So the very first thing that any competent court-appointed attorney in a post-conviction case getting this claim, this information, these allegations is going to do is going to be call Ann Taylor. Ann, what's your side of this? She's much more likely to talk to them. And there's a couple reasons for that. One, their successor counsel. They're there to act in his best interest. Your job was to act in his best interest. You want to help them be able to act in his best interest. If it would not be in his best interest to go forward to a hearing where you will testify, you will make that crystal clear to the defense attorney. You will make it crystal clear over the phone, not in writing. You'll have that conversation. Here's what I'm going to have to say if this goes forward. Because then the attorney can go through the same thing we just did at the trial level and go have that cost-benefit analysis conversation with the client. You know, if you go forward to this, here's what she's going to say. And unlikely, not impossible, not impossible, but probably unlikely that it's going to corroborate what he has to say. She's not going to be like, oh yeah, I lied to him about this or whatever. So the risk is Bryan Kohberger comes out of an evidentiary hearing, not only not getting any kind of relief, but now he looks like a liar. And he looks like somebody who is blame shifting, who is not taking responsibility. He's trying to shift it onto his lawyer. That's the risk. What's the upside? Well, if she's going to get on the stand and say none of this is true, and again, if she's the attorney, I think she is, she's got notes, she's got documentation, she's got other, people who were there, whether that's co-counsel, investigator, whatever. And just the bottom line is that this is going to be like any other situation where there's a double standard when it comes to the defendant's testimony. If it's a he said, she said, court is almost invariably going to side with the person who is not the criminal defendant. If they don't have any corroboration or any substantiation, frankly, sometimes even when they do, I don't know how many cases I've seen where it's like the defendant said this and they had 10 alibi witnesses and I find them all not credible. I find the police officer instead credible. They can do that. But it just, my point is the upside is really low. If she's going to get on the stand and dispute this factually, then the likelihood of him winning just went very, very low. He says his family, his immediate family members were present at these discussions. This is one of the reasons why I didn't want to like jump on this yesterday, be like, ooh, I have all the ideas and whatever. I wanted to see the actual petition and everything supporting it first, because I wanted to be real sure. Did he submit an affidavit from a member of his family? He did not. He did not. Now, maybe reasons why. This is a form. There's nothing in the form that says, have an affidavit from a witness who supports you. So conceivable, maybe just didn't know you could do that or doesn't have the right form to be able to do it or something like that. But it is something that absolutely is going to be followed up on now by the defense and the state. His family. He put his family in the middle of this. So his family is going to be on the spot. Can they support this or not? That's a tough position to put them in. Don't know what they have to say, obviously. But anything short of wholesale adoption of his position, well, now you've got the risk of seeing that as betrayal. Right? Bryan's putting this forward. Family doesn't back him up, then his family didn't have his back. Tough position to put them in. If they do substantiate it, then no issue. No issue. But that is something that is absolutely going to be followed up on. It will be followed up on if he gets a court-appointed attorney. The state doesn't, at this point, have a mechanism to compel anything from them. So, they don't have to cooperate. No idea if they would or wouldn't. Suspect they probably wouldn't, but if they don't have to, why would you? But they're certainly going to try. If there's no court-appointed counsel, then we're stuck with what we have. And then the only question is going to be, does what we have here justify a hearing? If we get counsel, we might get to fluff it up, add some more evidence, things like that if there is available. We also are going to potentially get a preview of what would happen if we got a hearing from Ann Taylor that would give us some idea about whether this is a good plan or maybe it would be better to withdraw this, given the low probability of success. And, again, this is hypothetical, high probability that it's just going to make him look bad. Costs are paid by the county. So this is our timeline. Application's been docketed July 27th within 30 days after the docketing or within any further time the court may fix. They can ask for extensions of time. The state shall respond by answer or by motion, which may be supported by affidavits. At any time prior to the entry of judgment, the court may grant leave to withdraw the application. This is why counsel gets on the phone and what are you going to say if this goes forward? Figure out if it's worth your while to even go forward at all. This goes to another nuance in post-conviction law, which is that you get one bite at the apple, typically speaking. There's exceptions to that as well. It's just how all of this gets so convoluted and complicated. But the general rule is you get to file one petition. And so sometimes if you got other things maybe that are on the horizon that you may want to raise or something like that, just other viable grounds, might be smarter for you to go ahead and yoink this one. Because if they decide this one, then that's it. You're done. You don't get to raise new things. That's not really likely to be an issue in this case because of the time frames. He's got a very short period of time before the time to file the petition runs. And so that is going to also encompass time to file additional claims. When the attorney gets appointed, if the attorney gets appointed, the attorney can, like I said, fluff up the claims that are already here. We can present more evidence in support of them. We can do all kinds of briefing about it and, make the legal argument and so forth. But what we can't do is add new claims to this unless we're still within that deadline, that time frame to be able to file a petition, period. And there's not a lot of time. Even if a new attorney is appointed, say today, your deadline runs out August 22nd, right? 30 days from the date of sentencing, and a year after that. So August 22nd, you got a little over 3 weeks. It's not enough to review everything and investigate and come up with new claims and so forth. Not impossible, because sometimes you can just sort of pro forma it and then fill it out as you have more time to develop, review and develop the specifics, but it's just tough. So that's where withdrawing the application kind of fits into all of this. The court can amend, etc., extend time. Court shall take account of substance regardless of defects of form. If you don't do it exactly right. You don't have to use this form. It's convenient, and so it makes sense to do it. But if you just handwrite it on your legal paper with post-conviction petitions, they're typically going to go ahead and consider that too. Subsection B. When a court is satisfied on the basis of the application, the answer or motion, and the record, that the applicant is not entitled to post-conviction relief and no purpose would be served by further proceedings, it may indicate to the parties its intention to dismiss the application and its reasons for so doing. The applicant shall be given an opportunity to reply within 20 days to the proposed dismissal. In light of the reply or on default thereof, the court may order the application dismissed or grant leave to file an amended application or direct that the proceedings otherwise continue. Disposition on the pleadings and record is not proper if there exists a material issue of fact. I want to try to translate this into normal person speak as best as I can, because it does kind of get convoluted in the context of post-conviction relief. And what we're ultimately going to get to here is we're going to look at sort of the decision tree that the court is likely to go through in analyzing these different claims to decide this issue. Is this going to justify any kind of further relief? And so what this is doing, first off, it's saying, is there any question of fact? That's number one, a material question of fact, meaning not just any dispute of fact. Okay, we know that there are going to be disputes of fact because we know, or we can assume, let's just assume, I think we can fairly safely assume that Ann Taylor is going to dispute that she lied to Bryan about, the life sentencing stuff, or, promised him, made promises to him about what prison life would be like. So that's a dispute, clearly a dispute of fact. But that doesn't necessarily make it a material dispute of fact, because it only becomes material if whether that answer is right or wrong determines your ability to get relief or not. If that changes the legal significance of your claim, one way or the other, it's material. But if it doesn't matter and you wouldn't get relief anyway, even if she did, then it's not going to matter. Subsection C, court may grant a motion for summary disposition when it appears from the pleadings, depositions, answers to interrogatories, admissions, and agreements of fact, together with any affidavit submitted, that there is no genuine issue of material fact and the moving party is entitled to judgment as a matter of law. This is the kind of classic summary judgment standard. If they do proceed to an evidence phase, then it can still be decided on summary judgment. If there's, the facts are clear and the law can be applied, in a straightforward fashion to those facts, then, you don't have to go on to have a full trial or whatever. The application then shall be heard in. This is, again, if it goes forward, it shall be heard in and before any judge of the court in which the conviction took place. So this is going to Judge Hippler in Ada County, because that is who convicted him. A record of the proceedings shall be made and preserved. There will be transcripts of everything that happens. The court may receive proof by affidavits, depositions, oral testimony, or other evidence, and may order the applicant brought before it for the hearing. If the court finds in favor of the applicant, it shall enter an appropriate order with respect to the conviction or sentence in the former proceedings, and any supplementary orders as to rearraignment, retrial, custody, bail, discharge, correction of sentence, or other matters that may be necessary and proper. The court shall make specific findings of fact and state expressly its conclusions of law relating to each issue presented. This order is a final judgment. That means it is appealable. When it's a final judgment, it is appealable. So this is the process if they have an evidentiary hearing. So this petition is going through several stages of vetting. We're getting the first stage of vetting, probably right now, while there's consideration of should he have an attorney appointed. And so that is the consideration. Is there any plausible reading of this petition under which he would be entitled to relief? If so, he gets a lawyer. If not, he doesn't. And if not, he doesn't, that's typically going to be a pretty good indication that they're going to summarily dismiss it. Why? Because if it's plausibly entitled to relief, then you get a lawyer. It's only if there's no plausible way that this justifies, under the legal standards, giving you a new trial, letting you withdraw your guilty plea and send your case to trial, then you didn't get the lawyer, right? So it's a preview of how the court views the merits of the case. Plausible at this point. Then you go to the summary adjudication, and that's basically going to be a question of taking this on its face. So first off, the state could just file a motion. Okay, we saw that. State could just file a motion to dispose of this on its face and say, even if you accept all of these factual allegations as true, they don't meet the standard to get a new trial. They can also say, these allegations aren't true, and here's the real facts. Submit affidavits in support of that. Different ways that they can go with that. So the court's going to, depending on the response it gets, then look at this on its face, and we're going to look at, is there any material fact? Is there any material disputed fact that we need to take evidence on to decide if he's entitled to relief or not? Or could we just go ahead and accept the facts as they are and decide based on that? Only if he decides plausible interpretation entitles him to relief, plus there's potential disputes of fact here, would you go forward to have the evidentiary hearing so that those material issues can be evaluated? He can make findings. Ann Taylor did say this, Ann Taylor didn't say this, whatever. And then evaluate the legal significance of that. So those are our approximate stages of vetting. This is what I was talking about before. All grounds for relief available to an applicant under this act must be raised in his original, supplemental, or amended petition. In other words, it needs to be in this. If he gets an attorney appointed, then the attorney needs to raise it timely, ASAP. If you don't get it in by the timeline, it's waived. You might be able to establish an exception, but you're always on the back foot with that situation, because the presumption is going to be, you don't get to raise it, and the burden's going to kind of be on you to show why you should be able to anyway. Review of the final judgment may be reviewed by the Supreme Court. So if he loses this, whatever ruling, if he wins it, then the state, this is not a conviction, this is not a criminal conviction or something like that where the state doesn't have the right to appeal. The state has the right to appeal this too. So both of them would have the right to appeal, and under their rules, the appeal automatically goes to the Supreme Court of the state. They have 42 days to file the notice, not the 30 that is the normal for non-capital appeals. So that is basically it. We've got, after that, some of these kind of, procedural, administrative types of observations. That's our statutory outline. Okay, gives us 10,000-foot view of the process that we're going to be going through. What that's going to look like, and general look at what the standard is going to be. So now it's time to talk about the standard and how that is going to apply to this petition. So first thing I want to point out is this issue right here. I want to make sure we can see it. It's very, very small, but let me scroll down to where we need to be. This is Criminal Rule 33. This is important because this is the standard to withdraw a guilty plea. Yeah, where did it go? I just got rid of it. Here it is, subsection C. This applies in the post-conviction context, this standard. And so generally speaking, only supposed to do it before, but you can do it after you've been sentenced, only to correct manifest injustice. To correct manifest injustice. So that's what he's asking for, asking to withdraw the guilty plea. It's after sentencing. He is going to have to show a manifest injustice. What does that mean? Well, that, I am just here to tell you, is quite a difficult standard to meet. Because it isn't just that there was an error, even that there is an error that could have contributed to some kind of defect in the process. Basically, manifest injustice means it has to render the whole thing unreliable, or it has to render the whole thing problematic. Manifest injustice is always really difficult after a guilty plea. It's always really difficult after a guilty plea. Why? Because the plea is an admission. The plea is an admission. This is, I know, come up a few times. Let's just go ahead and look at the plea stuff. We're going to turn to that now. The plea agreement itself. Make that bigger. This is the plea agreement that was signed. This is what is stipulated to by them. This was the deal. This was the deal. He will plead guilty. He will be sentenced to these things. State can seek restitution orders. Defendant is stipulating he understands the nature of the charge, acknowledges he is not being coerced into entering his plea of guilty. He understands the consequences, including the maximum penalties, mandatory minimum, etc. C, by pleading guilty, he waives his rights to a jury trial, to confront accusers, and to refrain from incriminating himself. Because pleading guilty is incriminating. He further acknowledges that he is satisfied with his legal representation, has reviewed with his attorney all possible defenses, and by his plea of guilty, voluntarily waives those defenses and all claims based on his constitutional rights. Guys, this creates a pretty strong presumption that that's what the facts are. He understands if it were to proceed to trial, he would have a right to appeal, included but not limited to issues decided before the guilty plea, the admissibility of evidence, the judgment, the sentence, findings of guilt, issues regarding the guilty plea, etc. If he were to go to trial, all of that's on the table. When you plead guilty, everything related to guilt, the decision of, whether it's in your interest to go to trial or not to go to trial, you've waived it. You've waived it. Further, defendant understands that if he were to proceed to trial, he would also have the right to file this Criminal Rule 35 motion. This is an Idaho process that they have where you can go ahead and go in and ask for the judge to give you a lesser sentence for reasons. Defendant hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to Idaho Criminal Rule 35. This is really important because this post-conviction petition, this is not an appeal. It's not an appeal. This is a very important technical distinction because if you're a layperson looking at it, you're like, he's asking a court to review it. Sure looks like an appeal. And I agree, it does, but it's not. This is a technically very different thing. The appeal is your right that you're granted to get the review of the legal errors, review for legal errors in the process that led to your conviction. Post-conviction proceedings, these are basically at the discretion of the state to decide if you get to have it or not. And if you do, what does it look like and what's the scope of it? So like we said, it's a separate process. It's a civil process. This is not an appeal. So it's very important to understand that these waivers for purposes of appeal don't mean that he waived his right to seek post-conviction relief. He didn't. It's not in here. It's not in here. Nothing in this says he waives his right to pursue relief under the Uniform Post-Conviction Procedure Act. He didn't waive that. So he does retain this right. But as we're going to see, there will be some overlap with kind of how courts look at these kinds of things, even though this is an appeal, is not an appeal. There are ways in which the court looks at claims in a post-conviction petition with skepticism when this is the product of a guilty plea. This is the entire agreement and understanding between the parties. This is the entire agreement. So there are no hidden deals, extra things that weren't mentioned or whatever. This is the entire agreement. This was it. Now, you guys might remember if you were here when we watched the guilty plea, when I watched the guilty plea, and I was late watching the guilty plea because I was camping, like literally just got out of cell service area when he goes into court to enter his guilty plea, and I was gone for like a week. And yeah, I still remember coming back from that and getting back into signal range, and my phone blew up, all of the notifications. But we did watch it. And you guys will remember that I pointed out there's nothing in here that says he can't do an Alford plea. Now, I was saying it wrong at the time because it was a malapropism. You know, my brain wires crossed. I kept calling it an Anders. Anders is a different case. Anders is a case that has to do with if you get a frivolous appeal. The reason why that was on my mind is because the topic of conversation at that point is, well, what if he files an appeal from his guilty plea? Well, the attorney would file an Anders plea, an Anders brief, good chance, because he waived it. And there's nothing in the record that would say his waiver was not knowing, intelligent, and voluntary. He would need evidence outside of the record to be able to do that. And so it would need to be presented in a post-conviction petition, not an appeal. And so that's what he is now doing. But anyway, that's why I had Anders in the mind, not Alford, but he had, under this plea agreement, the ability to do an Alford plea. And an Alford plea is the one where you maintain your innocence. You say, I didn't do it. I'm just acknowledging that there's enough evidence here that creates a risk that I could be convicted. And so I'm choosing to take advantage of the plea offer. Sometimes prosecutors will condition their plea offers on it not being an Alford plea. So that would be in the plea agreement if that were a condition. You have to do a straight plea. You can't do an Alford plea. It's not in there. And that is kind of further substantiated by this document here. Let's get this one big. The guilty plea advisory that was filed. It's got the statements of his constitutional rights. You have the right to remain silent, et cetera, et cetera. He's go through and initials all of these different advisements. It's giving up his right to remain silent as to his guilty plea. He has the right to be represented by the attorney. He knows that. Presumption of innocence. He knows that. You have the right to a trial. You know that. Waiving your right to a speedy and public trial. Right to confront the witnesses testifying. He's acknowledging all of these things one by one by one. Then we go to in the questions regarding his ability to enter the plea. So we go through this. A lot of these, as you can see, are kind of, you know, are you sane? Are you drunk? kinds of things. But, you know, some of these things that kind of may be implicated by the claims that he's raising in his petition. Are you mentally incapable of understanding it? This came up, you know, just vis-a-vis the autism. Does that, you know, there was never a competency process in this case. There was never an allegation that his autism disorder made him incompetent to participate in the legal process, meaning he doesn't understand it. He can't meaningfully participate in his own defense. So didn't come up. He's not alleging that. Anything going on that affects your ability to enter a voluntary guilty plea? Anything going on in your life pretty broad? Anything like you're feeling threatened by stuff, you know, feeling leaned on? No, nothing like that. Any difficulty understanding what you're doing? No. Any other reason you can't make a reasoned-informed decision? No. Now, the plea agreement itself, is the guilty plea the result of the plea agreement? Yes, it is. He's read it. He understands it. He understands it's non-binding, meaning the judge doesn't have to follow it. Has your attorney or anyone else forced or coerced you in any way to accepting this plea agreement? No. No, it's right here. Any other promises been made to you that have influenced your decision to plead guilty? No. No. Anyone told you what your sentence will be? Yes. Been told 4 fixed life sentences consecutive without the potential for parole, as well as the 10 years consecutive for the burglary. He's not reserving his right to appeal. Understands he's waiving his right to appeal. He has waived his right to appeal his sentence. Concurrent, consecutive, you know. This is just a very, you know, detailed, comprehensive advisement of all of these different things. Can't withdraw your guilty plea. Even if you get more restitution, you know, than you think you have, you're going to have to submit a DNA sample. Like, this is really, really, really thorough. You will lose your right to hold public office, to be on a jury, to carry firearms. You could be found a persistent violator. These are direct and collateral consequences of the guilty plea. Relationship with your attorney. There's a whole section on it. This. Yes, he's had sufficient time. Yes, he had adequate time to fill out the form. Yes, he had adequate access to his attorney's assistance. The attorney can get discovery. Have you had the opportunity to review the discovery provided by your attorney? Yes. Do you want your attorney to take any further action in the case? No. Do you understand that no one, including your attorney, can force you to plead guilty in this case? Yes. Are you satisfied with your attorney's representation? Yes. Do you understand that by pleading guilty, you will waive any defenses, both factual and legal, you believe you have in the case? Yes. This is, of course, facially in conflict with what he is saying now in the petition. Doesn't mean what he's saying in the petition is untrue. Could be true. But we have to acknowledge it's in conflict with what he said before. Now, most of the rest of this stuff. Are you entering your plea freely and voluntarily? Yeah, he says he is. This is what I wanted to get at, because this, I think, is this is What led me into it? Are you admitting to the elements to which you are pleading guilty? Yes. Or are you pleading guilty because you are entering an Alford plea? No. This seems to not be a situation where maybe I didn't enter the Alford plea because I didn't know it was a thing. It's on the form. You said no. How did you know to say no? This implies at the bare minimum, this implies there was a conversation with counsel about what does this mean? Alford plea? What's an Alford plea? How do you know how to answer this question if you don't know what an Alford plea is? He's not entering an Alford plea. He's admitting the elements to the crime. This is a problem from the manifest injustice standpoint because, yeah, waived his right against self-incrimination. Entered a plea that was not an Alford plea. This is not an absolute bar on getting post-conviction relief, doing a non-Alford plea. But it does make it a lot more difficult because it just makes it a lot harder to overcome if a court is skeptical of your petition, doesn't really want to grant you relief. It's just, it's low-hanging fruit. It's right there for them to hang their hat on. Well, there's no manifest injustice here because he admitted he was guilty. Period. We're done. No basis to withdraw the guilty plea. Makes it very, very difficult if you don't have a court that is sympathetic to your position. Hasn't had any trouble answering the questions which he couldn't resolve by discussing with the attorney. Understands it, had the opportunity to ask questions, doesn't need any additional time. If the court accepts it, you may not be able to withdraw it later. Yeah, he understands that. Anything else? Nope. Discussed it with the attorney? Yes. This is a very thorough and comprehensive form signed by all of them. Note 629, 629, 629. Typically what you do in this type of a situation when you're formalizing a plea deal is we're sitting together in the jail and we're going through this form. We are going through it piece by piece. And this one looks like Bryan himself filled it out. Sometimes I, as the attorney, will ask them, we'll get the verbal, what's your answer? I will write it down. I mean, different ways to do it. But typically, yeah, we're going through all of this line by line. Any questions about any of it? Or, at the very least, go through and stop. I'll watch you fill it out. Our plea form was like not really this complicated. But at the very least, like I would watch you fill this out so that I can be there if you don't know how to answer any of these things. So I can tell you what that means. And then you can decide what the answer is. And then we can talk about how do you want to answer this. And then that's why you get through everything and there's no more questions and everybody signs it at the same time because you're sitting there in the jail doing it together. That is very common. Obviously can't guarantee that's what happened, but that's just what it looks like. That's what it looks like. You guys will remember as well that the judge went over this with him during the guilty plea. It's about 5 minutes. I'm bringing this up. I don't necessarily want to rewatch it because we have already watched it. But the important things for this purpose were that he was placed under oath in order to, reiterate these things. So it is not some unsworn statement, not under penalty of perjury or whatever. But otherwise, it was a fairly lengthy, like 6 minute, 7 minute colloquy that the judge went through with Bryan, reiterating basically what's in the form. A lot of what's in the form. You understand what you're doing. You've had the opportunity to ask questions. You've had the opportunity to do the investigation that you think is necessary. And the things that needed to be said to get the guilty plea through were said. And it was not Alford. And there does not appear to be any reason why it could not have been an Alford plea, if that was his position. That he is in fact factually innocent, but wants to take advantage of the offer because he doesn't like his chances at trial. All right. Executive decision. We're not going to rewatch it. It's out there. Easy to find. I covered it on my channel. I just paused and talked through some of it. But this particular one is what channel? Oh yeah, Idaho News 6. So if you want to find it, it's there. The next thing I'm going to show you guys is this. This is characteristic of what I am calling the dim view. Dim view that courts take under these circumstances. This is a case from the Supreme Court of Idaho from 2023, a relatively recent case, and it's factually pretty on point. After pleading guilty to second-degree murder, Jonathan Hernandez filed a post-conviction petition alleging his trial counsel was ineffective for promising Hernandez he would not receive a sentence of more than 10 to 15 years. Following this alleged promise from his attorney, Hernandez pleaded guilty and signed a written plea agreement and guilty plea advisory form. At the change of plea hearing, the district court placed Hernandez under oath and confirmed that Hernandez and his attorney had reviewed the guilty plea advisory form. The district court later sentenced Hernandez to a unified term of life in prison with a maximum period of confinement of 45 years. Following an unsuccessful appeal, Hernandez petitioned for post-conviction relief. At the hearing on the state's motion for summary disposition, the district court found that any error Hernandez's counsel made was cured by a colloquy that took place between the district court and Hernandez at the change of plea hearing. There, the district court confirmed answers Hernandez gave on the plea agreement form and the potential sentence Hernandez faced. The district court granted the state's motion for summary disposition and dismissed his case with prejudice. He now appeals. For reasons below, we affirm the judgment. So procedurally, as you can see, like I said, it's very similar to what we're dealing with in this particular case. Now, there's a little bit of a different situation in that the specific representation he's alleging was made to him was that he wouldn't get sentenced to more than 10 to 15 years. And so if he believed that, and that was his incentive for pleading, and that was legally incorrect, you have a decent argument. You have a decent argument. So we're in the ineffective assistance of counsel universe here. From the case law standpoint, the origin, the standard, and so forth is Strickland versus Washington. But when we're talking about a guilty plea, there's a subsequent case, Hill versus Lockard, which is where the Supreme Court applied Strickland to plea agreements. What if my attorney gave me bad advice? And that induced me to enter the plea. If they hadn't given me that advice, I wouldn't have entered the plea. That's, if I shorthand with like a Hill statement or a Hill argument or something like that, that's what I mean. It's ineffective assistance of counsel in the context of a plea agreement. So that's what he's alleging here. He's alleging my attorney misrepresented something significant, right? The actual sentence that I could be exposed to. But the court says summary dismissal. Summary dismissal. It's important to understand how the court got there. So we've got to get to the standard here. A petition for post-conviction relief initiates a civil proceeding in which the petitioner must prove the allegations in the petition by a preponderance of the evidence. He has the burden to establish the facts. This is different from trial, different from direct appeal. This is the bane of post-conviction attorneys when you get handed a case where your defense counsel, your trial counsel, didn't make a record of anything. If the defense counsel had the trial counsel had like made a record of all these like possible errors that maybe you see, then there's a much better chance those can be raised on direct appeal. And on direct appeal, you don't have the burden to establish facts. It's a different standard of review. But by the time you get to post-conviction relief, now you've got a burden. You got a burden of proof. So it's very unfavorable. It's really, really frustrating. But it is what it is. That's our context. Summary dismissal of an application is the procedural equivalent of a summary judgment under the civil rules. It is permissible only when the applicant's evidence has raised no genuine issue of material fact that, if resolved in the applicant's favor, would entitle the applicant to the relief requested. On review of a dismissal of a post-conviction relief application without an evidentiary hearing, the court must determine whether a genuine issue of facts exists based on the pleadings, depositions, and admissions, together with any affidavits on file. So really, it's just like civil summary judgment. Is there something material here that needs to be adjudicated, that we need to take evidence on in order to resolve whether you're entitled to relief or not? Or is the dispute that you've identified immaterial? It doesn't matter, because even if it goes your way, you still wouldn't be entitled to relief. That's the framework we're within. Inferences should be liberally construed in favor of the petitioner. However, summary dismissal may be appropriate even where the state does not controvert the applicant's evidence, because the court is not required to accept either the applicant's mere conclusory allegations unsupported by admissible evidence or the applicant's conclusions of law. If you're conclusory, meaning you file a petition that says, I was coerced, they don't have to credit that at all. What they need are facts. This is what I was talking about with the specificity. If you're just telling the court where you want it to end up, I was lied to, I was coerced, I was misled, without specifics about what that means, the court is going to look at it very skeptically. So it is far more interested in the specific facts that you've alleged happened than it is in what you think the significance of those are, because it's going to decide that. So we're going to go back to the petition and work through some of this, but just going through the outline again to clarify how these things get sorted out. The analysis: A, Hernandez failed to show that, but for his counsel's promise, he would not have pleaded guilty and instead would have gone to trial. That's how they get to it. They get to it on the prejudice prong. They get to it on the prejudice prong of the ineffective assistance of counsel claim. Hernandez argues that the district court erred in summarily dismissing his petition for post-conviction relief because the allegations taken as true presented a material issue of fact. Specifically, he maintains his promise of a specific sentence fell below an objective standard of reasonableness because the attorney knew she could not guarantee what the court sentence would be. And 2, he would not have pleaded guilty had his attorney not improperly advised him. So then we go through the Strickland standard 2-prong test. Attorney's performance was deficient, unreasonable under an objective standard. What would a reasonable attorney do in this situation? This falls below that. It is a deferential standard, strong presumption that what you did was reasonable. And then, was it prejudicial? How did it affect the case? If it's just hypothetical, you know, my attorney made a mistake about, I don't know, a detail that doesn't matter that much. How did that affect the outcome? If it didn't affect the outcome, then you haven't met the standard. And then some case law that points to, often we'll just jump straight to prejudice and say because you can do that. You know, you can avoid the complicated problem of having to figure out exactly what happened or pass judgment on defense counsel's performance or whatever by just saying, even if it's true, doesn't matter, wouldn't have affected the outcome. So they will often do this. They'll just kind of jump straight to prejudice and dispose of your case based on that. The proper presumption in the cases. This is important. Hernandez claims that the language in this Idaho case, which the state relied on in its motion for summary judgment, creates an irrebuttable evidentiary presumption that conflicting statements given after sworn testimony can never be rebutted. Hernandez argues that simply because his sworn statement to the district court that no one had promised him a particular sentence conflicted with his later allegation should not mean that the former statement is more trustworthy than the latter, particularly in summary disposition proceedings. While we disagree with the breadth of his assertion on how such conflicting statements should be analyzed, we agree generally that conflicting statements do not give rise to an irrebuttable presumption. The statements given under oath during a plea hearing give rise to a rebuttable presumption. What does this mean? This was that plea colloquy where they went through that plea statement, you know, a lot of the same things that were there in the plea statement. Have you had an opportunity to talk about this with your lawyer? If you had the opportunity to do the discovery that you needed to do, did you get to ask all the questions that you wanted to? Are you satisfied with your attorney's performance? All of those things happened. It's presumed that that's true, but it is rebuttable. But you're starting from the standpoint of that's what the court's going to think is true, is what you said in the guilty plea hearing. So they go through the Hall case a little bit. We don't necessarily need to get all the way, but basically it's the same kind of thing. The Idaho Court of Appeals reasoned that a promise to receive a certain sentence by counsel did not raise the possibility of a valid claim for Strickland prejudice. The Court of Appeals reached this conclusion by analyzing the answers that he made on his guilty plea questionnaire, affirming that no one had made any promises to him about his sentencing. These answers directly contradicted the claims Hall was making on appeal. The court reasoned that Hall could not succeed in establishing Strickland prejudice because the sentencing court specifically informed him that it was not required to follow the plea agreement and could impose whatever sentence it felt was appropriate. The Court of Appeals held that even if Hall's counsel impermissibly made such a promise, the sentencing court disabused Hall of any misunderstanding before he pleaded guilty. Thus, he could not have been prejudiced by the alleged deficiency of his attorney. The standard can be read to create an irrebuttable presumption that once a court has conducted a colloquy under oath of the defendant's answers to the plea agreement, the defendant is foreclosed from later challenging those statements. However, to the extent that Hall can be reviewed to create an irrebuttable presumption, we wish to clarify. We acknowledge that there may be occasions, even if only very rare ones, where the statements made by a defendant while under oath or in a sworn written document can be shown to have been entered under duress, or if the defendant did not enter a knowing, intelligent, and voluntary plea. There also may be the rare occasion when the allegations of a petitioner in a post-conviction relief case, when viewed against the record of the plea hearing, can overcome the high bar necessary to show that such statements were incorrect when made. Thus, the presumption from Hall is not rebuttable. That said, statements made during a plea colloquy or in a plea of guilty form carry a strong presumption of veracity that constitute a formidable barrier in any subsequent collateral proceedings. This is because, bottom line, solemn declarations in open court carry a strong presumption of verity. So there's some other, discussion of that basic legal principle. But that is such an important backdrop because it is absolutely going to be at issue here. They're going to say, we presume that what you said in the guilty plea statement that we just looked at was true. And so have you presented enough here to overcome it? Given that we expect that's going to be rare, we don't credit your, conclusory assertions and so forth. We consider the record as a whole. This case, he didn't overcome the rebuttable presumption. Hernandez's post-conviction petition failed to include specific evidence beyond his own statements sufficient to rebut the significant presumption of veracity from his sworn statements to the district court. He also signed 2 documents, the guilty plea advisory form and the written guilty plea, which without more create a high bar which Hernandez alone cannot overcome. Indeed, without the testimony of his trial attorney corroborating the statements he now makes in post-conviction or other evidence providing clear proof explaining why the initial statements were false, we cannot reach any conclusion other than such new statements are patently false. That's going to be our legal context, and that's why counsel getting appointed or not appointed is kind of a critical decision point in all this, because he said he has witnesses and he's going to need corroboration. He's going to need something to corroborate this. And that could come from Anne. That could come from one of his immediate family members that he says was present. But he's going to need something. This, standing in and of itself, isn't going to get him there. It's not going to happen. So that's going to be pretty critically important. Let's go back now to this petition, so that we can go ahead and work through it kind of systematically. And in light of everything that we've talked about here, kind of what the standard is and what the process is and how all of this is going to be looked at going forward. During attorney-client discussions, most of which included all members of Bryan Kohberger's immediate family, petitioner was convinced to falsely confess to capital murder and felony burglary by coercion, disinformation, false promises, and the withholding of exculpatory discovery. All of this so far is conclusory. I was coerced, promises were made to me that weren't true, and exculpatory discovery wasn't provided to me. But he does then get into some specifics, so that's what we're going to have to focus on. The following is material to the inception of the plea, which he is alleging. This is not the clearest way of saying I would not have pleaded guilty but for these things, but that's the gist of what it's saying. It's material to the inception. It's material to why it happened. 1. Counsel's failure to inform petitioner of exculpatory discovery received during plea discussions, namely clumps of unknown hair found in Ethan Chapin's hands, as well as a failure of further inquiry. First specific allegation. Ann Taylor didn't tell him that Ethan Chapin had clumps of unknown hair found in his hands, and didn't investigate it, didn't follow up on it further. A lot of things going on with this. I'm going to come back to this one because I guess I will just preview. That's the one that I think is significant. These other two probably don't matter as much. Petitioner was convinced that actual guilt was not an important factor in considering plea acceptance. Death row was imminent and advised to lie. Petitioner was to gain a, quote, legal victory in entering a false plea. So this is a specific sort of allegation, but it is, again, it's also a little bit conclusory. He was convinced. Okay, well, but by what? Well, death row was imminent. Advised to lie. He would gain a legal victory in entering a false plea. This is difficult to reconcile with what we already saw about the Alford plea. He said specifically, no, I'm not doing an Alford plea. This implies you know what it is. You've already answered all the questions that you had full opportunity to talk it over with your lawyer to get clarity on everything. You're admitting the elements of the crime because you are in fact guilty, not an Alford plea. And then that was repeated verbally at the guilty plea hearing, very specifically. Are you pleading guilty because you are guilty? Yes. And that was a sworn testimony. This is going to be very difficult to overcome just on its face right now. So he is likely to need appointment of counsel to supplement this, or, himself independently. I guess theoretically, yes, he could, if he knows he needs to do that. I have no idea if he knows he needs to do that or not. I would think if he knew he needed to do that, you would do that up front. He would have already done it. It's his mom. His mom was there. I would think his mom's always putting money on his books. Think you could get an affidavit from your mom if it's going to substantiate you. So we don't have that now. If he gets an attorney, then possibly they would be able to talk to mom, talk to dad, talk to whoever else was present, see if this could be substantiated. It's kind of important, and it may have been rather unwise for him to say that all of his members of the immediate family were present for these hearings, because if they don't then provide statements, the court's going to notice that. They're going to notice that, and they're going to apply that against him. If he doesn't get a statement when he says he has witnesses, they're going to count that as against his credibility. He was unable to back up what he said the corroboration would be. So he really needs it, if not from Anne. And I think from Anne is probably unlikely, because I doubt Anne is going to say, why, yes, I did tell him to lie. Not impossible, but that would be unethical. She's probably not going to admit to that, even if it were true. So probably going to need the family to back that one up, or we're going to run into this problem where we just saw in Hernandez. You said you were actually guilty. So you saying this now without any kind of substantiation beyond your own word, it's not going to overcome the presumption that what you said in the plea hearing and in the plea agreement was the true thing. Next part, a gross misrepresentation of and promises regarding what a life sentence would immediately afford petitioner. This again is conclusory. Gross misrepresentation of death row in Idaho, including, okay, now we get into the specifics. elaborate fabricated story of Counsel's horrific experience touring an actual 8x8 death row cell. Now, fabricated is also conclusory. He doesn't know if it's fabricated. How does he know it's fabricated? What's your proof that it's fabricated? And that it isn't just something that you're now disagreeing with because your personal experience is different than what was the experience of your lawyer being communicated to you. See the difference between the conclusory and the specific? She told him a story about touring an 8x8 death row cell. He alleges it's fabricated, but he hasn't specifically set out why. All communicated to petitioner and his family, allegedly by IDOC through counsel, and thus constituting threats and promises made to induce a plea agreement. Again, this is conclusory, and it's going to run up against the presumption that when he entered his guilty plea agreement and he said, I'm not being coerced, no other promises have been made to me, this is the full agreement of the parties, etc., that was the true part. So once again, he's gonna need some really specific, really just corroboration, not of this general idea of, yeah, she told us about touring an 8x8 cell, but why it was fabricated. On what basis is it fabricated? Yeah. Even if it was, again, you're going to run up against that problem of you pleaded guilty, you said you were guilty. So how is it a problem if you had a misunderstanding about what you thought prison was going to be like? How is that material? Even if it's true, even if she did lie to you about what prison would be like. How is that material in light of you admitted you were guilty? Challenge. So that's why, from my perspective, these two don't have a very good chance of going anywhere. The meat of this is the first one. Withholding exculpatory evidence, yeah, could potentially be a problem because that affects your cost-benefit analysis. And when you're deciding, should I go forward to trial? Should I take my chances with the jury? Or should I plead guilty for whatever reason? This would be much easier if it had been an Alford plea. And we don't have that presumption that he was being honest when he said that to have to overcome. If he had done an Alford plea, then it's real clear that your whole decision to plead guilty is based on that cost-benefit analysis, and therefore distortion of that cost-benefit analysis by false information, by withheld information, etc., would be much easier to establish as material. So that's going to be a nuance with this one. Is this going to be enough to overcome what he said in the guilty plea, that I'm pleading guilty because I am guilty? That's tough. But then we have to get to the exact claim that's being made here. We have to work through was there undisclosed exculpatory information in light of our whole record and everything relating to this. And so we gotta nail down what it is that we're talking about here. Clumps of unknown hair found in Ethan Chapin's hands. Okay, guys, that is coming pretty much verbatim from the Christopher Whitcomb book, Broken Plea. I have not read Broken Plea. Full disclaimer, read nothing but commentary about Broken Plea. Broken Plea is a book that is basically questioning, challenging the plea agreement, the plea process. It's suggesting that there were problems with it, and it's based in substantial part on information that was provided by a defense expert. I believe his name was Jonathan Turvey. Brent Turvey. Had his name wrong. Brent Turvey. He was a crime scene analyst that was hired by the defense. So, based on his information, Broken Plea presents this claim that there was a clump of unknown hair that was found in Ethan Chapin's hand. And Bryan is arguing that was exculpatory and should have been further investigated. We have some information in the record about what this may be relating to. Is this true? Was there, in fact, a clump of hair that was found in Ethan Chapin's hand? It's not really clear that that is the case. So the first thing that we have in the record, let me make this bigger. This was one of the documents that was unsealed after the guilty plea, and lots more stuff that was sealed pre-trial as being too prejudicial started to become public. This is an FBI laboratory report. It was filed by the defense as a stipulation that this was going to be admissible at trial. This FBI report. And so what we're talking about here, of course it's highlighting weird. Item number 3, it's characterized as debris. Debris from the right hand of Ethan Chapin. And, it's just basically a lot of trace evidence, right? This is a report about a lot of trace evidence that was collected, submitted to the FBI for analysis. But item number 3, in the right hand of Ethan Chapin. Okay, it matches up with this this clump of unknown hair. So does clump of unknown hair equal debris? Results of these examinations, items submitted from Ethan Chapin, including item number 3, as well as these other items, were examined for hairs microscopically consistent with hairs found, hairs in the head sample from Bryan Christopher Kohberger. However, none were found. Okay, that's what we know about this from the FBI report. Something from item number 3 was examined microscopically, determined not to be consistent with Bryan Kohberger's hair. So this is already exculpatory. That's very important, I think, to this to this analysis of whether this is a material fact, because it was already exculpatory. It was already in the discovery. It was stipulated to be admissible. If there was something additionally exculpatory or something that additional investigation would have revealed to be like more exculpatory, then maybe we still have something to work with. The FBI report isn't the only thing that we have about this particular piece of evidence, because we also have, these are the defense's expert disclosures. So this is a massive document, as you can see, 1045. This has, there's like thousands and thousands of pages that have been unsealed. I have not read everything, probably am not going to, really never intended to, because I look at the case, you know, and like the case was done, so it doesn't really matter. But now the case is not done anymore, right? So might have to go back and look at more of it, but it'll depend on what the state's response is. Anyway, I'm just bringing this up because of the things that are kind of worth looking at, in my opinion, this document is one of them, because it's got a substantial amount of basically the defense's theory of the case. A whole bunch of expert witnesses and their reports, their anticipated testimony, and so forth. So Ruth Ballard was the defense's DNA expert. She reviewed the testing that was done, the DNA discovery, and so forth. All of these different reports, the FBI, the Idaho lab, all of these different, the cybergenetics, the defense did their independent true allele probabilistic genotyping, reviewed all of that, all of these other things. So we're going to get through to, I'm just trying to scroll until we find the FBI lab item number 3. Okay, decedent Chapin's body at autopsy. FBI lab item number 3. Morphologically consistent with decedent Chapin's own reference hair. Morphologically dissimilar to defendant's reference hair. So again, it's just reiterating, it's exculpatory towards Bryan. It's not his hair. It's not his hair in the hand. It's somebody else's hair. It's one hair. I think this is important. It is one hair. It's not a clump. It is not a clump of hair. It is one hair. That calls into question. There are lots of reasons why Dr. Turvey is providing information to Christopher Whitcomb for purposes of this book. There's a lot of reasons why I find quite a bit of it, again, not having read the whole thing, but just the commentary I've seen about it, very lacking in credibility. The mere fact that he's talking at all, if he did not get a waiver of confidentiality from Bryan Kohberger, the very fact that he's talking at all is a huge problem for me. Because you are under the same requirement to keep your mouth frickin' shut as the attorneys are. And violating that doesn't sit well with me. Now, I don't know if he did or if he didn't. It's possible that Bryan waived. I don't know. But factual misrepresentations about the evidence are also going to be a problem. So already here we have, I have some concerns about Dr. Turvey's information. He describes a clump of hair. The FBI lab report says it's one, and that it's consistent with Ethan's hair, inconsistent with Bryan Kohberger's hair. A lot of other, stuff that she reviewed. This one is, I think, particularly helpful because you get to the kind of bottom line of what her opinion is and her conclusions and stuff based on her review of all of this information. And so these are her basic conclusions. I'm not going to go through and read everything that she said. Good support that his DNA was found on the swab from the sheath. Okay, the STR analysis that they did, good support that it's his DNA. Their DNA expert is not contesting that. But the problem is, you know, there's no transfer. There's no, you know, just other of these issues make the case, yes, very perplexing. And I agree. I mean, this has really never been a straightforward case that's really, really easy to reconcile the state's account with the evidence. But the bottom line here is just that, you know, there's a lot of opinions here and a lot of things that are being identified and stuff like that. At no point is she contesting the FBI's characterization of that item as one hair that is morphologically consistent with Ethan and morphologically inconsistent with Bryan. All right, so let's talk about what that means. Morphologically consistent. Definitely does not mean that it's Ethan's. Hair analysis, not precise at all. It's a microscope. It's another eye test. There's no like standards and stuff like that. I mean, there's no objective standards in the sense of like with fingerprints, you know, X number of points of comparison allows you to say it's a match. You don't have anything like that with hair analysis. So what microscopic hair analysis, generally there's agreement that like the scope, the limits of what it can do. It can tell you if it's animal or human. Okay, that's not really helpful for ruling out, you know, or ruling in any particular person. It can tell you where on the body it came from. If it's a human hair, you know, is this head hair? Is this body hair? Something else? And it can often tell you something about racial or ethnic background. Different characteristics of different hair types associated with, you know, different racial groups. And that's about it. So in and of itself, being morphologically consistent with Ethan's hair, not real specific. It just means it's included him, but if lots of people have hair like him, brownish white guy hair, it's not particularly helpful in terms of excluding other, you know, possible contributors. Excuse me a second, my throat's... Oh, our wildfire smoke is starting to get to me. It's that time of year. So it's not particularly specific information. So what tools could have been available to explore it? They can do analysis. They can do more genetic analysis of hair. They can do mitochondrial DNA analysis. That's also not super precise because it only traces a matrilineal line. It's not as individualized as if you can do an STR test. If it doesn't have a root, you can't do STR testing on it. If you only have a shaft, you're typically, at least historically, you were stuck with mitochondrial DNA analysis. However, couldn't help but remember that very recently in the Rex Heuermann case, there was a whole bunch of litigation over a new process that was developed, a next-gen sequencing process that was able to develop whole genome sequences from unrooted hair. And so this went through a whole Frey-Daubert type hearing over there in New York to test the validity. It was admitted in court. It was going to be admissible in trial against Rex Heuermann. And so whole genome sequencing is extremely individualized, like even more than the STR testing that we already do that calculates these likelihood ratios and the, you know, quadrillions and octillions and so forth. Very, very, very precise. So that was available. That was available. The problem, I think, that this claim is going to run into is that the fact that it was available doesn't mean it was unreasonable and therefore deficient performance not to do it. We already know it excludes Bryan Kohberger. So the value that it has is to potentially help us identify a different suspect, right? Help us get some information that we could use to maybe try to develop a lead that would point us to somebody else. If it just corroborates that it's Ethan's, that's not helpful either. But as we sit here right now, the testing hasn't been done. It hasn't been requested to be done under the actual innocence, angle. And so we don't know whether it will simply confirm that it's Ethan's hair or whether it would be some third party. If it's some third party, we still don't know. Does that mean it's the perpetrator? Is it hair that was like on the bed? Is there like some other, if we're able to like trace it to see who it is, that there is some innocent explanation for, the hair being present, and there's a struggle. There's obviously a struggle vis-a-vis Ethan. And this hair ends up in his hand. The problem here is that, yeah, it was potentially helpful. It was potentially helpful, but we don't know that it would have been helpful. We can't sit here with our preponderance of the evidence standard that we have to meet and establish this was, in fact, not just exculpatory, but extra exculpatory, because it would have pointed to a different perpetrator. That's the challenge with being in the post-conviction context where you have the burden of proof. If he gets counsel, one of the things they could do, theoretically, potentially, amend this petition to add that request for the DNA testing, the actual innocence claim, based on this. But that would depend on the court deciding likelihood that it would point to somebody other than Ethan, likelihood that that person would be the actual perpetrator. And the fact that we have this unrebutted characterization by the FBI that the defense expert didn't contest, and that's part of our record that's going to go up, it's going to be before the court reviewing this petition, is that it was similar to Ethan. Yeah, this is a tough one. This is a tough one. If it was an unrelated person, if we knew it was an unrelated person, would potentially be helpful. But it doesn't necessarily establish unreasonable performance, because while defense counsel has a duty to investigate, particularly exculpatory evidence and potential defenses and so forth, it doesn't mean that you're ineffective if you don't run down every single possible lead that is available to you. Okay, high profile case, you get 20,000 crank calls. You don't have to follow up on every single one of them. That is not the standard. If you make reasonable decisions about why it's not necessary, why it's not helpful, those are strategic. And that will be upheld. So as long as your decision to forego testing is based on a plot, based on some kind of reasonable explanation, it's not deficient. So that's an issue with this. But then you get to the problem of prejudicial. Prejudicial, you got to show it affected the outcome. We don't know. We don't know what analysis of it would show. If it just confirmed it belonged to Ethan, which is entirely possible on the record that we have, that gets us absolutely nowhere. That adds nothing to the information that was already available at the time that the plea was entered. So yeah, guys, I think this is pretty tough. Pretty tough call. $1 million question, really. Does he get a lawyer? Does he not get a lawyer? Because I think if he gets a lawyer, they will have the opportunity and the ability to possibly be able to flesh some of this out in a way that would make it more likely to withstand the summary disposition. If he doesn't get a lawyer, this standing on its own is not likely to go very far. Now, I have some thoughts about what the state could do, how it might respond. As we saw, it's got options. It can just move to say on its face the petition isn't good enough, even if these things were true, doesn't entitle him to relief. I think they could probably get there with 2 and 3. I think they could get to summary adjudication on 2 and 3 because they can point back to his plea statement. Now, granted, there is stuff in the plea statement as well that suggests he had time to do all the discovery he wants, to do additional investigation, ask all the questions, etc., and that he was satisfied with that. But if he was legitimately misinformed about what the evidence was, and he was legitimately kept in the dark about something, exculpatory, potentially exculpatory, just a better chance, I think, that the court would take that kind of allegation seriously and not treat it as, well, you said you know everything. How do you know what you don't know? Until you find out. And we don't know in what detail the discovery was reviewed with Bryan. We don't know. We definitely know the defense team had it and reviewed it, submitted it to their own expert to analyze. Expert didn't, contest any of it. And we know they didn't pursue, defense didn't pursue any kind of follow-up to it. It's already exculpatory. So it's one that I think is the one that's got the best chance of going forward. And so given that, yeah, the state could definitely move for a summary dismissal of this. They could also submit an affidavit. Now, an affidavit, what could the FBI submit that would help here? The FBI could definitely submit a more thorough record of what this thing is that Bryan Kohberger via Christopher Whitcomb is characterizing as a clump of hair, but which the FBI characterized as debris and one single hair. They're going to have photographs from the crime scene. They're going to have the autopsy notes. They're going to have the chain of custody, for the debris. They're going to have the FBI's notes for when they opened up the package containing the debris and documented it and described it and so forth. So they could potentially submit all that just to establish it was not a clump of hair. Here's what it is, and what it is was already known to the defense. And that hasn't been controverted. So it wouldn't really surprise me to see something like that coming from the state, just because then the burden would go back to Bryan to be like, and so are we talking about something different? Do you have some proof of a clump of hair that is not, all of this information that the FBI has, their documentation and so forth? Something else here? Because otherwise that record is going to dominate the factual basis for what it is that we're talking about. So it wouldn't surprise me if they did something like that. Definitely wouldn't surprise me to see them pointing back to these same documents that, we already just looked at, to point out the defense already knew these things. Defense already knew it, made a strategic decision not to investigate it because it was already exculpatory. And so in the absence of a good reason to think it was going to be exculpatory plus, when it was consistent with Ethan's hair, number one, not unreasonable to limit. But even if it was, defendant hasn't met his burden. Petitioner hasn't met his burden to establish it would have shown a perpetrator, an alternative perpetrator. It would not just corroborate that it's Ethan. And that one single fact alone overcomes his admission of guilt in the guilty plea. So yeah, it just really depends, I think, on some strategic decisions that the state has to make vis-a-vis how they're going to respond. It's the safer choice to go ahead and just submit your affidavits and submit the evidence and everything, right? That's safer. Now you've done it. Because if you don't, and the court disagrees with you that summary disposition is appropriate here, because there's a dispute about, the whether he was not informed about exculpatory evidence, then you run the risk that this is just, this is going to go forward to a hearing. And, further this goes in the process, the closer you are to a potentially bad outcome where the plea gets withdrawn and we're having to take the case to trial. And the state does not want to do that. The state doesn't want to do that. They would not have entered the guilty plea in the first place and gotten basically no benefit out of it had they wanted to just go forward to trial and pursue death. So I don't think that that's likely to have changed. So it's a safe thing to do, to present all your evidence, but strategically, sometimes it does make sense to not, because it suggests you're giving it more credit than you think it deserves. If you really think it's worth summary disposition, then you treat it with the contempt that you have for it. And you just stick with the, this is bullshit kind of response. And don't worry too much about presenting something that could potentially open the door for the judge to decide, oh, well, but now we've got a factual dispute. We need to have a hearing. Therefore, you just take it on face value, even as it is, even if this were true. And so that's kind of where I suspect the state's going to go, is some kind of middle ground. I could see a situation where they move for summary adjudication, but they submit the affidavit with the documentation of item number 3 to the FBI. Here's what it is. Here's the photograph of it, etc. just so that we can clarify when Bryan Kohberger says, quote unquote, clump of hair, this is what we're talking about. And then put it back on him to dispute that. So I could see something like that. Any plausible interpretation that entitles him to relief? Frankly, guys, I think it just depends on how generous the court is feeling. This is Hippler that we're talking about. Hippler, Judge Hippler will make the decision. He has not come across as particularly sympathetic to the defense. Not Mr. Kohberger personally, nor really the defense in general. But I'm not going to say it's a 0% chance. And the reason why takes us all the way back to the very beginning. How does this sit with people? How is this going to sit with the judge? I read it and it instantly makes me wonder, oh, is he that guy? Is he that guy? The judge knows this has waived attorney-client privilege. Judge knows this has opened the door for Ann Taylor to get on the stand and say exactly what happened and why. How the whole plea agreement came about, what the decisions were based on, etc. And it's possible that that would provide a kind of increase in our confidence in the outcome here that otherwise the guilty plea really kind of didn't give us. You know, yeah, okay, he said he's guilty. I'm taking his word for it. I'm not going to argue with him. But now he's arguing with himself. So now it's kind of back on the table, I guess. But it was always a challenge with this case being very strange from the facts, not being the typical situation you see where somebody commits a crime and you arrest them, and then you do all of your subsequent investigation of their phones and their devices and their whereabouts and everything like that. And you corroborate on all of these different levels. We did not see that in this case. And that was what was so remarkable about it. You expect that, you didn't get it. Not a single instance where they could put him in the same room with any of these people. Not a single instance where they could, find him on their social media or whatever. A lot of competing back and forth about, well, he wiped his devices. Well, but no, he had an artifact on his computer, but there's no evidence he ever ran the program. It was always a little bit of a mess. And so I was at the time, and remain perhaps even so now, quite critical of Mr. Thompson's decision to just give away the death penalty in the case without requiring something substantial in return. What he got in return is we didn't have a trial, but the cost of not having the trial is that this all didn't get vetted in court. So it just remains these live disputes. And what he could have done, he could have done something akin to what they did with Gary Ridgway, the Green River Killer. All right, we'll take death off the table, but you're going to have to provide us some inside information, some information that can verify your involvement, some information that can just basically corroborate what you're telling us. You're going to tell us everything about how you did it, why you did it, why, there's this paucity of corroborating evidence. How was that achieved? Be really great, although difficult at this point in time with the scope of the discovery and everything, but really great if he could provide some inside information that's not public. Anything like that would have been helpful in terms of just resolving the open questions about the case. And the fact that he didn't require that, it just raises a lot of questions for me about why. Now, I know his explanation, he wouldn't tell the truth anyway, so well, but you have ways to validate that. You have ways to validate if he's telling you the truth or not. You get to follow up on what he tells you. You get to cross-reference it against the evidence that you already have. And if he lies about it, I mean, that in and of itself is at least a piece of information that we would have. So just the lack of interest in that is baffling to me. It was at the time. It very much remains the case now. I don't understand why he didn't do that, because it would have helped resolve, potentially anyway, some of these questions. He can either answer them or he can't. He's willing to or he's not. If he's not willing to, then why are you giving him this plea bargain? Why are you so lacking in confidence in your case that you would just take death off the table to get rid of a trial? To alleviate your chance to prove it? Just very, very difficult for me to understand that. And so the consequence of that decision, in my mind, is that, yeah, he said he did it. Okay, that was good enough for me. It's probably good enough for lots of people. I'm sure not going to argue with him about it. But now he's trying to take it back. And I mean, we can't argue that, yeah, false pleas definitely happen. People plead guilty to things they didn't do a lot of the time. Now, obviously, I've got issues in this particular case with whether that happened here, given the availability of the Alford plea and so forth. Everything that we've talked about. You could have done it that way, and he didn't. So that just doesn't look real consistent with the position that he's taking now. But I think it's perfectly valid for people to still have questions about, are we satisfied? Are we satisfied with this explanation of guilt, given everything that we know about the evidence in this case, the number of people, the blood, the lack of transfer, just everything? So the reason I got down this road is because Ann Taylor's testimony could be another way to alleviate some of that, because it would shed light on the thought process. Why was it decided that this was the best way to go? Why was this decided to be a straight plea and not an Alford plea? Was that specifically discussed? Yeah, these doors are all open now. And so when I say there's a non-zero chance that Judge Hippler will appoint him a lawyer, this is me putting on my legal realist hat. This has nothing to do with the legal rules and principles and the plausibility and so forth. This has to do with the judge having his own thoughts and motivations and so forth, that guide his decision making. And I can definitely see a situation where a Judge Hippler is going to look at this and everything it implies and think, oh, you know what? He wants a hearing? Let him have it. Let him have it. Because this is a big old door that this opens. And this could resolve some lingering questions about how and why this guilty plea came about. So that's my thoughts on this, guys. So a lot more than thought I was going to be able to get through in one sitting. But I definitely want to have some time to see what you guys are thinking and asking and stuff as well. Lazy LCH, what are the chances he saw Nestor's performance on Corey and decided she was ineffective? LOL. Different attorney. Nestor was the Tyler Robinson attorney, and Corey Richins. Anne is not that lawyer. Anne, from what we were able to see of her, in my opinion, was pretty good. I mean, definitely from a just demeanor standpoint, that initial, like, ooh, this person grates on me or doesn't. I did not get strident from Anne, like, at any point. If I were going to nitpick what we were able to see of Anne's performance, it was just her questioning style. Sometimes not all that clear. She would have a tendency to assume, like, have a hard time maybe distinguishing between her background information and then what the rest of us know. And so her questions could be confusing because they assumed we knew a lot more than we did and that we understood where she was going and stuff like that. So just a lack of kind of simplifying and systematically being able to lay things out to show us why these answers matter. That would really be my biggest complaint about Anne, again, from what we were able to see. And there weren't necessarily like a ton of contested evidentiary hearings and stuff like that. But there were a few. She had like Detective Mowry, Detective Payne on the stand. We got to see how she handled them and stuff like that. Very, very, very different from Kathy. But we also, at least since these records started getting unsealed, we have a much clearer picture of the scale and the scope of the defense investigation, how many people she was conferring with, how many people she hired, how much review they did and stuff like that. And I can't point at any of that and find fault. It appears to be an extremely comprehensive, diligent investigation. Yeah. I can't say I have my own complaints about Anne. Cranky Coffee, is it possible Ann Taylor advised him secretly to take the deal and fire ineffective assistance of counsel later and told him what to say? The reason why I think that's unlikely is because if she were advising him about this, she would have submitted an affidavit. Because she would have told him, here's what you need to do, and here's how you'll get like past this initial hurdle to clear the merits review and stuff like that, to clear the summary disposition. You need corroboration of your claims, and that's me. And so here's my affidavit. I don't think this involves her. It seems pretty clear to me, based on the allegation, the clump of hair. Somebody read Chris Whitcomb's book and decided I didn't know that. I didn't know about clumps of hair, whether it's in good faith or not. Like, I believe what the book is saying, and I didn't know that, and therefore, that is something Anne didn't tell me, and now that undermines my trust in Anne. That is possible. But it's hard for me to reconcile that with the second two. Also, she lied to me about death row and told me to lie, and take a false plea. Those are harder for me to reconcile with this is Anne being involved, and this is a good faith belief that what's in Christopher Whitcomb's book is true, is something beyond what I already knew, and not just like this is a pathway for me to try to get an advantage. Again, I'm trying to be as forthright as I can about my knee-jerk reaction to this. Why it looks so bad to me. I saw nothing from Anne at any point that raised any concern with me that her objective throughout this entire process was anything other than getting the best possible outcome for Bryan that she could. I mean, the more that comes out and the more I see about what the defense did and how, much just the steps that they took to prepare to fight this case at trial, she was a freaking warrior. She went to battle for this guy. Because I've been in the role of the defense lawyer, I have the perspective on it that I do. That, in my opinion, given the nature of that relationship and everything that she knew and everything they would necessarily have to talk to each other about and so forth, my opinion, she was his number one ally, no question. That is your job as the defense lawyer. That's it. You're their number one ally. You keep their secret. You work to get the best outcome for them that you can. And you shut up about it. I mean, there are literally cases where my client's on video committing the crime in front of me. We can watch it with our own eyes. Okay? I am still going to try to get the best outcome for that client that I can. That's my job. And I'm going to sit in the chair next to him when everybody else is like, I saw the video. The guy is guilty as fuck, okay? Given what's coming to him, I am going to sit by his side and fight for him because that's my job. My job is to sit next to the people that nobody else on the planet wants to sit next to and be the one person that's on their side. And so that's a big part of my experience, my background, my bias, I mean, whatever you want to call it. When I look at this case and I look at what Ann Taylor did for him and I look at how she tried to fight for him, I see that. I see that. And so when I see this petition, what I see is I see that being discarded. devalued. Oh, Turvey has something else to say that is more helpful to me? Then under the bus, this dedicated ally who fought for me for years, under the bus she goes. She's no longer useful. Being very forthcoming about my bias, because I'm not saying that that is true. And evidence could change my mind. But I do not want to ignore my knee-jerk reaction to it. This is a betrayal. Now, she's not going to cry about it. She's not going to complain about it. She's not going to retaliate for it. She's not going to be like, oh, fuck that guy. I'm going to go give a declaration to the state then. Some people will. Lifetime true believer public defenders will not. Because it's also part of the job. It's also part of the job. You know that this kind of thing happens. You know that this kind of thing happens. And your job is, it's not about you. It's not about your ego and defending yourself. People make accusations about me and how I did as counsel. I am going to sit there quietly and say nothing until somebody puts me in a position where I am compelled to tell my side. Now, I might have words with the client, depending on the situation. You realize what door you just opened. And if I get subpoenaed, I'm going to have to tell them that this is all lies. But that's because I am still trying to do what's in their best interest. I am not allowed to lie, and I am not going to lie to get my client off. An outcome that's based on a lie wouldn't be in their best interest anyway. But I'm going to let you know, this is an unwise door to be open, and you might want to reconsider it. Because it's in your best interest not to push this further. But I'm not going to tell the state a damn thing until I'm under oath and I'm compelled to. I am not closed to new evidence. Like I said, opportunity here for affidavits, more information, etc. But just this alone on its face, that's why it sits very badly with me. Because that's the impression it gives me. It reminds me of similar experiences that I have had, that other lawyers have had, that I have seen, challenges like this go through the process. It reminds me of that. Doesn't mean it's the same, but it's a natural association for me to make. So yeah, no, I don't think, I don't think this is Ann driven. If anybody is driving this, it's Turvey. But I have no idea if they, have any contact or anything like that. I mean, goes back to did Turvey contribute to Whitcomb's book completely on his own without any kind of confidentiality waiver? Or is there, some relationship with Bryan that goes back? I don't know. I don't know. If there's no confidentiality waiver, I do have to wonder, this is really getting down the road now, a bit far afield. But if this petition doesn't get anywhere, which, odds are against him Odds are very much against him of this getting very far. And even if it does get to the hearing, of that being helpful for him. But if this petition doesn't go anywhere, will Turvey be next? He violated confidentiality. I relied on him, filed the petition, etc. I don't know. That's just one of those things. We'll have to wait and see how this plays out. Brian's Ramblings 0602. Idaho has put 3 to death since 76. I didn't know that statistic. It doesn't surprise me. I mean, actual executions are down pretty much everywhere. Florida, I just saw, set a double execution for pretty soon. They're like so far behind. Now we're going to do 2 a day or something. A little bit wild. I have looked at Utah recently because of the Tyler Robinson. I've been looking at their death row and so forth, and they got guys on death row that have been there for almost 40 years. So I think this is kind of a common issue. Ginger Puff 764. I learned so much from Andrea. Well, thank you so much. I'm glad that you find it helpful. I try not to ramble too much and go too far afield, but I think the context is important sometimes. The Becca Fly. If the court grants BK an attorney for this, can the attorney switch up the cause for appeal, remove ineffectiveness of counsel, and go in a different direction? So I touched on this a little bit, but the brief answer is that as long as they are within the time limit to file a post-conviction petition, meaning before August 22nd, they can add anything they want. They can change it up however they want. But once they get beyond that, they're going to be stuck with what's already presented. There's some room to like modify or tweak arguments or things like that, as long as it quote unquote relates back to the original allegation that you made. So you can't base it on like a different factual scenario. A good example of this would be like, you can't say I raised ineffective assistance of counsel, therefore I am going to now allege all of these other ineffective things that I'm saying counsel did. Those are factually distinct. So if you're beyond the time limit to file a petition, they're not going to relate back. They're not going to be timely. But you can rely on, for example, these specific facts. And if there are additional legal grounds to argue that they should justify relief, you can potentially do that. Might, like I said, be able to raise this actual innocence angle and do the petition for the DNA analysis. You might be a little tough on the it wasn't available at the time. The first time, like the whole genome sequencing that was used in the Rex Heuermann case, for example, that wasn't decided in his case until after Kohberger's plea. It was in like September, I think, of 2025. The technology existed, but it hadn't necessarily like been validated for court. Now that said, it had previously been used in Kern County, California, back in 2024. So that could be a hurdle. Remember, one of the issues with that element was that it wasn't available at the time of trial. So if the technology was available, you're going to have to go a different route to potentially justify getting it. But anyway, it's potentially, if it's based on the same issue with the clump of hair, quote unquote clump of hair, it's factually the same type of thing. So you're asking for different relief based on it. It's possible that you'd be able to do that. But to go into other factual disputes and stuff like that, if you're past the time limit to file the petition, that's generally not going to be allowed. Edward Edward Quinones Doyle, do you think AT planted an appeal Easter egg when she said denying a continuance could lead to ineffective counsel? Hippler denied it, then the plea deal happened. Was she preserving an appeal issue? She would have been preserving an appeal issue had he not pleaded guilty. Because remember, the guilty plea waives all that. It waives all that. And he's made these admissions on the record now that, yeah, we got to do enough. Got the discovery. There's no additional motions, no additional investigation, stuff like that that we thought needed to be done. So it kind of sits in a little discomfort, right? But part of the difficulty here is that preparing for a case is like writing a book or painting a painting or something like that. You're never really done. You just stop. At some point, you just have to stop. But you can tweak it forever. There's always more rabbit holes you can run down, more information you can follow up on, different types of tests that you could subject things to. You don't get to do everything you want to. It's really common and normal in these situations, meaning the continuance standpoint. She really did want more time. I don't doubt that. I don't doubt that the volume of everything that they had to deal with meant there were things she herself hadn't personally reviewed. I mean, it's just kind of inevitable. She didn't personally go through all of the, call data records that Cy-Ray got from AT&T and stuff like that. There's always limitations that affect your ability to prepare. Some of them are court imposed. The court said, you're going to trial this date. So, okay, you have to prioritize, and you might make a statement like this. There's other things you want to do. But there's typically, self-imposed ones as well, because you can't do everything, particularly when with something, so voluminous like this. You can't personally take the time to sit and watch every single piece of video surveillance that they collected from all of the different locations and stuff like that. And, try to spot a white car and then, check the window, like all the, you just can't. So a lot of it gets delegated, to other people. No, I don't think this was really it, because, again, you don't have an obligation as the attorney to turn over every single stone. You get to make reasonable determinations that it's not necessary to turn over this stone. There's not enough to be gained. It's not likely to advance my case. It's not worth the trade-off of the time and attention it takes. And as long as there is a reasonable basis for making that decision, it's going to be upheld. So, no, I think by and large, the guilty plea took this off the table. Right? And she had her own colloquy during the guilty plea. Did you have the opportunity to do as much discovery as you wanted? And it took her a second to answer it, but she did. She said yes. And so now that's going to be presumed to be accurate. To Truth for Liberty, what are the chances if counsel concedes to being ineffective? BK still have to show likelihood of guilty, not guilty. Yeah, counsel's concession isn't always accepted by the court, because they recognize, yeah, there are some lawyers out there who are such true believers that they will absolutely throw themselves on the sword and be like, yeah, you know what? I didn't. And that was completely unreasonable. And I had no strategic justification for it. The court isn't necessarily going to accept that, because the court decides independently for itself what is reasonable performance or not. The attorney doesn't have some exclusive authority over that decision. The attorney can just testify about specific things that happened or didn't happen, thought processes and reasons behind the decisions that were made. But it's always going to be up to the judge to decide if that was reasonable. And then the prejudice is out of the attorney's control too. Even if I throw myself on my sword and I'm like, yeah, you know what? I didn't have enough time to investigate. I should have asked for a continuance. It was completely ineffective of me to have not done that. We still have to establish prejudice, defense's burden, and post-conviction by a preponderance. Would have changed the outcome had we had more time. Why? What would we have discovered? How do we know that? How is this not just conjecture? Speculation. I have a burden to actually prove it. And that's the hard part of clearing the ineffective assistance hurdle so often, to such an extent that, as we saw from the cases, sometimes they'll just skip the unreasonable part. They'll go straight to prejudice. Doesn't matter anyway. Because even if she did totally screw it all up, it wouldn't have changed the outcome. It doesn't matter. And then you have that overlay in this particular context where he wants to withdraw his guilty plea, has to show a manifest injustice. His guilty plea was a manifest injustice, and it is very hard to do that when it's an acknowledgement of guilt plea. It is a straight guilt plea. It is not an Alford plea. He said, I'm pleading guilty because I did it. Very difficult to overcome that. Edward Quinonez Doyle. Problem is, this goes to Hippler equals denied. No, well, hopefully, you probably asked this like a couple hours ago now. Yeah, you did. I see 303. If you stuck with me this long, then I don't think it's that straightforward. I really don't. I think there absolutely, if all he wants to do is get rid of it and not give it a second thought, he can deny counsel. He can summarily dismiss it. At least provided the state does enough to establish, for example, the clump of hair, here's what it is. Here's what they already knew about it. Here's why, it was already exculpatory. Nothing new to add. But I am not 100% convinced that that's what he would want to do. He could see this as an opportunity. This is Bryan digging himself a hole. Great, here's your shovel. I could see that from Hippler. Truth transparency. Thanks, Andrea, for always being thorough and willing to have the tough convo. Mods, I come for you guys too, trust me. Well, because the mods are awesome. Thanks, Lana. I appreciate it. This has been quite a roller coaster ride, and I've tried to be as frank as I can about my evaluation of it, really from day one and all the way through. My perspective has changed, from day one, and that's because the information has changed from day one. But I still, try to remain open to, I'm aware that my knee-jerk reaction to this is like, wow, this makes him look like that guy. Try to be open to, I'm aware of that. And so therefore, if there's evidence, I will reconsider it. But I never want to, pretend to be some blank slate that I'm not, and just people aren't in general. But you know what this reminds me of too, is that I have so much going on right now. It's crazy. Here we are talking about Bryan Kohberger, which I was not expecting, it's out of nowhere. I have this massive stack of Alice Evans exhibits that, yes, I have been going through, and boy, do I have a lot to share about that, still in progress. There's stuff that was going on in Luigi's case that I had some thoughts about that I wanted to share. That's still a work in progress. We're going to get Tyler Robinson's probably today. It's probably up on the exchange now. It was the deadline for the state to file their brief on the probable cause. There's like all these things going on all at once, as it always is. But one of the things I have been thinking about and starting to formulate, like a show or series that I would like to do, it was Tyler Robinson's case that got me thinking about it. But it really crosses over into a lot of these other cases that we've looked at. And it's a broadly speaking, how thinking works kind of presentation. Knowledge, basic epistemology 101. How do you know things? How do you know? How do we know what we know? How do we have confidence in what we know? What's the difference between what we know and what we believe? And how does this factor into the court process and this decision of, how do we figure out if somebody is guilty beyond a reasonable doubt? And I've been thinking about this because I don't want to go too far into the weeds. But so just bottom line, I get so many comments all the time, especially with Tyler Robinson, right? Oh, but Andrea, but Delphi, but Karen Reed, but Bryan Kohberger, why do you have this different opinion in Tyler Robinson? Well, because it's a different case with different facts and different evidence. And I feel like it would be helpful to show how the reasoning process works. It's about conditional probabilities and how it works when you combine them, okay? When you have lots of weak evidence, very little strong evidence, how can you process these things in a way that generates some kind of confidence? Guilty, not guilty. Gonna win at trial, probably gonna lose at trial. These are like ordinary reasoning processes we all have to go through, and it's what the jury does. But there is a method that is kind of systematized a lot of that. Bayesian reasoning, the Bayes theorem, great tool for being able to evaluate the strength of conditional probabilities. So I would like to do that. I would like to work through. Let's just apply Bayes' theorem to a whole bunch of these different cases that we've looked at, and see how it comes out. Anyway, that might be forthcoming. There are some like logistical challenges with how do you actually do that. I sit and run a Python script like on the stream. I gotta figure out like some logistics of how to work this, but I would like to do it because I think it would really help show where I'm coming from. Why, I got this opinion about this case, I got this other opinion about the other case, and this is why, because this is how I have processed the evidence. This is how I have weighed the inference of guilt against the inference of innocence, the hypothesis of guilt against the hypothesis of innocence. And here's how I have weighed that in combination with all of the evidence that's presented. I don't know. I think it would be interesting and helpful. But that will only be a tough conversation in the sense of like, what the fuck are you talking about, Andrea? Because I'm not a statistics expert, I'm not the pro on that stuff, but it's definitely something I have an interest in and think is highly applicable and helpful for this type of context. So anyway, stay tuned. That may be coming. I'm gonna do my best to like get through everything that I really want to talk about all at the same time. Lazy LCH, how much more money is this guy going to cost the taxpayers? I feel bad for them and especially for the families. They can't move past this. The statute gives people the right for the post-conviction relief. I mean, that just is what it is. It's there. I can't really Well, I mean, I can continue to point the finger, assign some blame to Bill Thompson for how he handled this guilty plea, and not requiring just something more definitive than I'm guilty, which is not really that difficult to come back and later say, well, I only said that because I was coerced or whatever. Even if you don't get something like novel, something that's helpful because it's the whole like information only the killer would know, always the gold standard for the statement from the defendant. At this point, he's had access to so much of the discovery. How can you even, identify something that it's not possible for him to know? But even if you don't get something like that you can point to and be like, definitively, see, he proved himself that he was guilty because he revealed this guilty knowledge that only the killer could have had. Even if you don't get something like that, I would just have to think there's some kind of psychological pressure, that if I have to get up and not just say that I did this, but also like talk about how and why and everything, it just seems like that's going to put me in a position where I really have to commit. And no, it's still not impossible to come back later down the road and be like, yeah, I made all that up. I just really wanted the guilty plea because of what my lawyer told me. And so I just said it. I just said things. It's not impossible that you can't come back and do that. But I just feel like it might at least be a little bit of friction, resistance, whatever, like knowing that you had gone on the record and said these things. I don't know. But I mean, the bottom line is that these procedures do exist. And there is a reason why there are so many ways out. So many ways where, like we've said, these forks in the road, these decision points that all have to be cleared for this to go forward and then get to the point of we've got a new trial. And a lot of opportunities from the very, very outset to just cut it off. You're like, nope, we're not taking this any further. And this is largely the consideration why. Because, yeah, there is concern for the victims. And reopening this, aggravating their wounds. They thought they had closure. Now they got to deal with it all over again. Yeah, that's not a good situation. And so, at least in theory, these laws are trying to strike a balance between we legitimately want to have an avenue to correct major injustices. We need to have that available. But it also has to be balanced against, we can't just let everybody come up and relitigate everything with their trial, or it defeats, the purpose of having had a judgment in the first place, because it's just never resolved. So, yeah, I don't expect this is anything that the victims' families are particularly happy to hear. Cost, it just depends how far it goes. Well, that'll be another consideration for Hippler. The Becca Fly. Andrea, do you think the judge should appoint counsel? I would prefer that he appoint counsel. It's just cleaner, in my opinion, when you do that. Because you've got now the second pair of eyes. Again, you've got the tell me your story, Anne. You got like some kind of mechanism to be able to evaluate what are we dealing with here? And what's going to happen? What's going to happen if this goes forward? Because we don't necessarily know that Bryan Kohberger has foreseen this. We don't necessarily know that he realizes you just opened up a great big freaking door that if you get what you're asking for, you might sincerely regret that. And so having counsel is potentially a bit of a check on that, because they get to vet the ability to substantiate this. And the risk of, no, actually, this is going to, severely backfire. So I would mainly prefer it for that reason. Plausible interpretation. I think the challenge, again, it just comes back to that exculpatory, failure to inform of exculpatory discovery. But did they? But was it exculpatory? Here's what it was. She obviously knew about it. I think he's justified if he doesn't, but I would really prefer that he does. Lazy LCH, doesn't having family present in talks with his lawyer make problems with attorney-client privilege? Seems to me he waived privilege. Well, yes, you do raise another issue here with the presence of the family members at the discussions. Now, he does say most of them. He doesn't say all of them. So we could have an issue figuring out exactly which ones they were present for and which ones they weren't. But yeah, that's again another reason why this is not a good admission to make. Could be an issue. Yeah, to maintain confidentiality, you got to be in the confidential setting. You don't waive confidentiality if you have your conversations in the presence of somebody who also has a confidential relationship with you. So if your psychiatrist is there with me, your priest is there with me, your doctor is there with me, your other lawyer is there with me, somebody on our defense team is there with me, then it might be covered. Now, there are tricks that people will play sometimes in situations like this to try to basically extend confidentiality to like a friend or a partner, or maybe a mom and dad, let's say hypothetically. And you do that by quote unquote hiring them. You hire them to be a part of the defense team. You have them sign a confidentiality, agreement, just like all of the other, like the defense experts and stuff like that have to sign them. You can try it. It's risky. I mean, because courts can look at that and be like, yeah, that's a sham. But it is better than nothing. It's not impossible. But yeah, everything else being equal, had an attorney been advising Bryan Kohberger on writing this petition, would have advised strongly against writing that sentence. Most of that clause, most of which included all members of Bryan Kohberger's immediate family. Not a good thing to be disclosing publicly. Potentially opened up a big door there. Alara S. Can they identify whether the hair is male or female? That's a great question. I don't know. They can't just visually. They definitely cannot by putting it under a microscope. Can they do? Because they can typically The problem is they don't have nuclear DNA if they don't have the root of the hair. So that's why they're stuck with doing typically the mitochondrial DNA analysis. And because the mitochondrial DNA is carried by the mother, by the matrilineal line, I don't think it in and of itself tells you if you're dealing with male or female, because it itself is going to be associated with the X chromosome. Everybody's going to have the X. So I don't know. I don't think there's anything there that would tell you. Yeah. I don't think so. So not conventionally. Definitely not microscopically. They can't look at a hair and be like, that's visually that's a male hair, that's a female hair. But there is maybe, I just don't know if it would require the whole genome sequencing and stuff like that to be able to identify if it's male or female, or if there's like a Y, some kind of Y marker that they'd be able to get from the hair. I don't know to that degree of detail. Aunt Boo Boo. If SV1, subject vehicle 1 or suspect vehicle 1 has fog lights, as many claim to see, and BK's car doesn't, is that extra exculpatory since the state associated SV1 with the crime? This is exactly the kind of thing that I would love to do the breakdown of how thinking works and the comparing that, like how we normally process the weight. How do we decide what weight to give evidence, and how we have ways to like mathematically calculate that now, your confidence in being able to be like, well, how strong is this? How not strong is it? And so forth. Because yeah, I mean, if the vehicle has fog lights and Bryan Kohberger's car does not have fog lights, then his car is excluded as being subject vehicle 1. That is highly exculpatory. But it depends on how good is the evidence that subject vehicle 1 has fog lights. If it's not real clear, then that's not a particularly strong inference. So it's kind of it depends situation. This is one of those things that can end up being a real issue in the jury room. Because if people are coming to different conclusions, we're looking at the same evidence and you're seeing fog lights and I'm not seeing fog lights, then it's going to be really hard for us to come to an agreement about how significant is this evidence. Because you think it definitively proves it's not his car. And I'm like, I don't see that. That doesn't carry the weight with me. And so the whole process of jury deliberations, a big part of the process anyway, is that coming to agreement on what do these things mean? How similarly are we seeing? It's this exculpatory, it's this inculpatory. And when we're not even on the same page about it, that can make it very difficult to come to an agreed verdict. If it's an important piece of evidence like this. This would be an important piece of evidence for somebody who's voting not guilty, right? Because it's strong. It's exclusive, rules him out. At least as to that, particular part of the theory. But without that, what other reason do we have to think that Bryan Kohberger was at the house that night? You got the DNA on the knife sheath. DNA on the knife sheath gets stronger when he himself has a knife and no apparent explanation for what happened to the knife. See, I'd like to be able to work through, because this is what Bayes' theorem is really made to do. It's made to allow you to evaluate your conclusion, the confidence that you have in a particular proposition, depending on how evidence changes. It's added to, it's taken away, etc. How is that going to change the dynamic? It does a really good job of breaking that down mathematically. But a lot of the decisions about like, well, how exculpatory is this? How inculpatory is it that go into that process of evaluating the probability of guilt or innocence, those themselves aren't necessarily universal, objective. They're perspectives. They're based on things like this. I see it, but you don't. Then how do we come together? It's hard. Bella Brat, for you. OMG, girl, thank you so much for your breakdown, how your brain works and how you work through this for us through so much info. Always think I know what I believe and then listen to you and I'm like, oh, I didn't think of that. Well, that is very kind. I realize that I err on the side often of saying more rather than saying less. Here we are approaching the 4th hour of this live stream where I like, hey, I'm totally not going to have time to say everything. But I am definitely not just trying to ramble and to speak without purpose. I do tend to have a fairly, at least in my mind, like logical order of my thinking. And so I try to share that and kind of help walk you through how that's working. And sometimes we take a very meandering path to get there. And I think today was one of those days. But hey, if you were able to stick with me until 4:31 an hour ago, thank you. Thank you. I do appreciate that. Great vote of confidence. Kang the Conqueror 2025, pivoting to the Tyler Robinson trial. How serious would it be if Candace Owens has footage that the judge didn't make public? Seems like she has the enhanced video. Thoughts on the Macron suit? If there is evidence that is non-public that has been disclosed to her, that is almost certainly going to be a breach of the gag order, right? Because it's limited access. Who has it? The state, the defense, and their respective teams, their witnesses. So no obvious other source of where they would be able to get that. Now, maybe UVU, and then somebody like did their own enhancement. Possible. Would UVU be covered under the gag order? Not real clear. But bottom line is, if she does, and that becomes publicly known, seems pretty likely the court would be interested in finding out where'd she get it from. And so obviously we saw how far that got us with the gag order leaks in the Kohberger case, right? Oh, we're going to appoint a special prosecutor and get right to the bottom of it. Well, when was the last time? When was the last time we heard anything about that? Did they find that leak yet? No, of course they freaking didn't. So I don't know how viable that would be. But I would expect the judge to at least go through the motions. Macron suit, I don't have a ton of thoughts on it at this point. I know they just had the hearing yesterday on the motion to dismiss. From what I heard about kind of how the argument went and what the judge was focused on, it sounded like not a good chance of the statute of limitations argument winning. More likely that the case is going to turn on the jurisdiction question, the forum nonconvenience question. Should this be in Tennessee? Should this be in Delaware? Why or why not? But not necessarily like kicking it out entirely. So I expect it to probably move forward based on that. But we have to see. Have to wait and see what the decision is going to be. The statute of limitations issue was like the most problematic one because, yeah, if the judge agreed French statute of limitations applies here, it's not Macrons are not in a good position because the French statute of limitations was like 3 months. So that would be pretty dispositive. But if he's not going to go down that road, then it just kind of becomes a question of process at that point. So these cases are often long and convoluted. It would likely be less so if it stays in Delaware because it would not be subject to Delaware's new anti-SLAPP statute. It would be under their old anti-SLAPP rules, which basically don't provide any protection at all. But that means you don't have to go through the whole process of pre-litigating your actual malice and then appealing it, and discovery gets stayed while all that's going on, and so on and so forth. That is becoming increasingly common with defamation litigation in the anti-SLAPP era. So my thoughts on that. Alara S., as the public, how can we advocate for trial? I mean, you can't really. It's not the public's call. You know, it's not the public's call. It's not a democratic process at this point. He pleaded guilty. That is what it is. The laws about withdrawing that also are what they are. And, you know, advocate to change rules. No. No, because you're opening a lot of doors if you do that beyond this specific case, and questionable whether rule changes that you came up with at this point in time would retroactively apply to his case, and so forth. So all I can really tell you is everybody has a right to say what they want, obviously. But in terms of like it having a practical impact, it won't. This is the judge applying the law to the facts that are presented to him, and we, the public, are observers to this. Harbinger of imminent death. Mr. Runkle has drummed into me how unreachably high the ineffective assistance standard is. What should that standard be? It is a high standard, and it's mainly because, yes, there is a lot of deference to counsel's strategic decisions. And there's also a lot of presumptions that decisions that could be strategic were in fact strategic. I might disagree with Ian a little bit on how high a standard it is. And I say that because I say it from the perspective of having won on appeal, like direct appeal, ineffective assistance several times, like not just once, like a few times. And that's largely because, at least in the direct appeal context, you're not litigating, you know, stuff counsel chose not to do or whatever. You don't have the record for that. That's all happening post-conviction. So I'm typically dealing with counsel's made a legal mistake, and it's really like obvious and significant. My attorney didn't raise this issue that should have foreclosed a charge from being filed. The attorney did not make this argument, did not request this instruction to support their defense that was available, and that made their defense kind of unavailable without getting that instruction. Counsel like erroneously believed that the instruction wasn't available when it was. Things like that. When it gets into factual decisions, it's much harder. I had a case that I had it on post-conviction. It involved ineffective assistance, failure to investigate, specifically failure to investigate DNA evidence. I didn't win it in my post-conviction in the state, even though I thought that I should have. Of course, I thought I should have. But no, I really did think that the decision was kind of bullshit. But he then took it up on federal habeas, and he won it on federal habeas. And that involved a situation where, like, the only real evidence of guilt was DNA. Like, that was it. It was DNA that was on, it just gets very complicated. A mixture on the sleeve of a jacket worn by the, believed to have been worn by the assailant, who basically stabbed a homeless guy who was fine initially and then later committed suicide, like died for unrelated reasons. And so anyway, so wasn't available as a witness to say identify anybody or anything like that. But the problem is that this all took place in basically a homeless encampment, and it's just everybody is like communal, like everybody uses, touches, has everything, and so it's like literally a small amount of trace DNA, along with other contributors. That was the evidence, and the defense didn't hire a DNA expert. Identified one, contacted him, got the quote and everything, got the order saying, yeah, proving funds to go and hire this defense expert, and then never followed up. And so that DNA ends up being the piece of evidence that gets the guy convicted of his third strike, gets life in prison without parole. And then subsequently, the expert, the DNA expert who the defense attorney had originally contacted, but then never followed up on, the defendant contacted him, submitted him what he had about the DNA, and the expert's like, oh yeah, the guy never followed up with me, and just by reviewing what's available from the discovery, there's major problems with this analysis and these decisions, and it's consistent with transfer or contamination, low level, low quality. The testimony that was given was terrible, right? Because she's like, it means he was the last person to touch the coat, like all these scientifically not justifiable kinds of things. So that was a situation where, yeah, they did not give deference to failure to investigate that DNA as a strategic decision, because it was so important to the case. It's so highly technical and beyond the expertise of the lawyer, which he said in his declaration to justify getting the expert appointed, that wasn't a reasonable decision not to investigate. The feds got there. My court did not get there. So anyway, I offer this all to suggest that I don't know that I consider it unreasonably high. I would say if I were going to modify and tweak one thing, it would be maybe that presumption that if it could have been strategic, therefore it was. If we can think up of any reason why this would have been a good decision, then we'll just impute that to the defense lawyer and call it good. I don't really like that, because it just, the judges are coming from a different context. They're coming from a different position. They don't have access to all of the discovery and the big picture. Like, what counsel's actual thought process was, I tend to think is important. I agree if it's strategic and it's plausible, like there's plausible strategic reasons, even if I disagree with it. I don't think you I don't think you like impugn the defense counsel for that reason. But just deciding it was strategic without any evidence that it was, I don't really like that part. So I guess that's probably the best answer I could give you. I'm not sure that it's actually that hard. Like, when there is a legitimate mistake, and like I said multiple times, like this was real clear, obvious, you got the law wrong, we're done. And it was very simple and straight. So simple and straightforward, I could get it done on direct appeal. But it's when it deals with these factual issues and investigation and stuff like that, it does get more complicated. Matthew McClellan, have you seen a guilty plea be undone post-sentencing? Did minimal research, found Norfolk 4 and maybe a few old law review articles, but not a lot. Not a lawyer though, thanks. Oh yeah. Guilty pleas can be undone post-sentencing. I'll give you an example. I've told this story before when I had my client who was a juvenile, and he's a juvenile. He's charged with something like residential burglary, something like that. It was breaking into a garage. Punk stuff, little kid punk stuff. My client was not a citizen. status-wise, my client was not a citizen. And so because of that felony conviction, always potentially dangerous from a standpoint of immigration consequences. We, like every jurisdiction, at least at this point, seems to be pretty universal. There's a U.S. Supreme Court case that basically says immigration consequences that result from a guilty plea or a conviction, these are direct consequences. And so you as the attorney have the obligation to make sure that your client knows those. You have to discuss it with them. So it's kind of made public defenders like little mini immigration lawyers, which is not, not a great state of affairs, frankly, because immigration law is extremely complex. But we have some resources and assistance and stuff like that, but it can be quite tricky. So anyway, yeah, we have to advise the client about consequences. So anyway, plea negotiations happening, whatever, clients going to enter a plea, but status is an issue. I'm raising this with the prosecuting attorney. Prosecuting attorney is like, well, you know, I work with all the law enforcement, you know all the guys, whatever, and there's the policies. And what I can tell you is that ICE isn't concerned about juveniles. They won't go after just a juvenile. Like it's their policy. Not going to happen. I'm like, well, I don't know. I guess I'll talk it over with the client. He says immigration doesn't really care. Your call. Client decides he wants to plead guilty. Pleads guilty. Gets a sentence. As soon as the sentence is done, boom. ICE is at the door. Picks him up. He's in the detention center over in Tacoma. And then he vanishes like into the process. He's like down in California or something like that. Yeah, this was a case where I threw myself on my sword and I filed the motion to withdraw the guilty plea. And I told the court, yes, this was ineffective assistance of counsel on my part because no reasonable defense attorney should ever freaking take at face value what a prosecuting attorney tells them. It's ICE's policy to do or not do. Like how freaking stupid of me was that, to believe that and to rely on that. Like that was dumb. Court bought it. Yeah, so he was not accurately advised of the consequences of his guilty plea, and he got to withdraw his guilty plea and did not end up getting vanished into somewhere in Mexico where he had not been since he was like 2 years old. Never lived, didn't even really speak the language. So that's an example of a guilty plea being undone post-sentencing. It's a personal story of how I made that one happen. So yeah, it does. It's not super common, but it definitely does happen. It's not a totally unheard of thing. The odds are going to be against it, and most of the time, but it's not insurmountable. And often it's going to be, again, it's like when it's legal mistakes. Oh, I didn't correctly calculate your offender score, and so I didn't advise you on what the right sentence was going to be, and now you're actually, I told you were only going to get 10 years and you actually got 30. Like that case that we saw with the Hernandez. That can be an issue. If the judge doesn't go through and correct it, if the judge just like relies on what I said and that's all you're advised of, yeah, that can be a problem. One of the things that we do with a guilty plea. So I talked about the Anders brief on appeal and why that's a common outcome when you get a guilty plea, an appeal from a guilty plea, because the appeal waives the guilty plea. And so very, very few and limited grounds that you have to appeal on. But you can sometime if they haven't been like properly advised of their rights or properly advised of, all the consequences and stuff like that. So that's what you do when you get an appeal from a guilty plea. You just go over the paperwork. Is there anything here? It's harder in the day of like standard forms. But you can sometimes find things, oh, here it is right on the face of this guilty plea statement. It's got the wrong sentencing range. So possibility he was misadvised. I got to look at the transcripts. I got to look at sentencing. I got to see if we're in a Hernandez, the case we looked at, type of situation where the judge corrected it on the record. But those things do happen. And so that's not unheard of to support it withdrawing a guilty plea. My attorney lied to me and coerced me about what prison life is going to be like. Probably not. My attorney advised me to plead guilty, even though I wasn't, told me to lie. Even if that's true, was that prejudicial? You could have entered an Alford plea. Yeah, anyway, those types of disputes are harder, not so much because they're about what counsel told me or what counsel didn't tell me. It's because they don't relate to legal errors. It's a fact claim. Establishing coercion is a fact claim. Oh, yeah. My attorney lied to me about, told me to lie to get the plea. Okay, but does that even establish coercion? It's like part of the problem, I think, with that particular issue. Even if that's true, okay, you didn't have to. You could have said, no, I'm not going to lie. That's against my morals. How is that coercive? Coercion is a totality of the circumstances type of consideration. So just one thing in and of itself. Counsel told me it was a legal victory. Is that wrong? Oh. No, but yeah, how does that make it coercive? It's not clear that it does. And so because a lot of these issues focus on fact disputes, that's what really makes it a more difficult standard. Harbinger of imminent death. Recently posted 2024 Karen Reed witness interviews. Would a competent attorney advise anything other than stop talking, dumbasses, and don't give up your phone? Legal advice is often a garbage in, garbage out scenario. You're giving advice. You're not God, okay? You don't have some omniscient view of what truth is. You're reliant on evidence, and a significant amount of which is what your client is telling you. Now, the longer you do the job, I think, the heftier the grain of salt that you give what the client tells you becomes. But the point is that you can only give advice that's as good as the information that it's based on. And there's a lot of room for, I don't know, just like misinterpretation, talking past each other, hearing what they want to hear and not what they don't want to hear. We have a whole big conversation where you tell me your version of the facts and I say, well, okay, if that is the case, then this. often you don't hear the if that's the case part. You just hear that then I told you to do this, and then this was my advice, and therefore I'm to blame when that goes sideways, even though the if part that you told me was a whole bunch of shit. That's not uncommon in legal advice. So, you never know to what extent things like that are at play. Generally speaking, if you don't have to voluntarily give law enforcement interviews, of course you don't. Rarely anything to gain, but people always still want to do it because they think it will make them look, it will make them look guilty if they don't. And they're not wrong. The cops are definitely going to think that. Lay people are certainly going to think that. It's just that, it can't necessarily hurt you in the sense that the jury can't necessarily find out about it. Like, almost certainly can't. You don't get to comment on exercising your right to silence. Well, I shouldn't have even said that because that gets complicated. Sometimes you can. But I mean, yeah, bottom line, if you're not under compulsion and you know that there is stuff you don't want him to know, even if it's not incriminating, like about this, even if it's just some other embarrassing thing that you don't want, you don't want the possibility of it getting out, which is everybody. Everybody has secrets. Everybody has things they don't want the whole world to know about them. And there's always a possibility in an interview or handing over your phone or whatever that's going to come out. Okay? If you don't have to, you don't take the risk. But people also get to make their own decisions. Another aspect of the legal practice. People pay you tons and tons and tons of money to get your very well researched, reasoned, thought out opinion that they promptly ignore. That's just part of it. The horse will decide if it's going to take the drink or not. Eclectic Jessica. Thanks, Andrea. Appreciate your insight. Thank you. Thank you, Eclectic Jessica, for being here with us. To Truth for Liberty. I think Anne previously raised Carpenter concerning OGG DNA. Can that be raised anew post-conviction based on Chatry? So not really, not in this context anyway, because we didn't have a trial. We didn't have a trial. So none of this was admitted as evidence or not admitted as evidence in a trial. It's moot, basically. Even if the judge had ruled specifically, even if they had litigated, should this geofence data be excluded, and the judge had said no, it's admissible. We never had a trial, so it never actually got admitted, so it's moot. It would just go into the kind of cost-benefit analysis of what do we do next. Could potentially factor into, a prejudice analysis in terms of, if we have to look at what the evidence would tend to establish anyway, vis-a-vis guilt, innocence, might apply it like in that sense to not count things that wouldn't be or may not be admissible. Chatry did not make it clear that that geofence warrants are a problem. It didn't hold that. It just said it's a search, so it's subject to the Fourth Amendment. But it didn't rule on the issues of, so does that mean it's a general search? Does that mean it's a dragnet, a suspicionless search? Or was this whole process where they get all of the information and then just only unmask when they have probable cause for a specific suspect? Is that okay? They didn't rule on that. So legally speaking, Chatry is of limited help for that kind of argument. Carpenter, I'm spacing right now on the real specifics of what Carpenter was based on. Can't remember. Did it have to do with abandonment of DNA? I don't remember off the top of my head. But it doesn't matter. Bottom line, wasn't a trial. Nothing got admitted contrary to the Fourth Amendment. So don't think there are going to be viable issues there. Matthew McClellan, I read continental, not analytical philosophy, so would find your philosophy videos interesting. Not a false dichotomy, but critical theory school in the past. I was myself much more of a continental philosophy reader than an analytical philosophy. When I was back in school anyway, I was all about the Heidegger and the Arendt and the post-Hegelians and stuff like that. I found it very fascinating. And I still do. I mean, it still is like part of a framework of my thinking. But as I have gotten older, like more on my own, I've looked a little bit more into the analytical side and the Bernard Russell and a lot of the philosophy of science stuff. Very interested in Popper. Yeah, the whole Popper versus the Bayesians. That's the kind of thing I'm talking about, like the how we think and the structure of logic and the structure of inference and things like that. Wasn't what I studied really in depth when I was in school, getting my old philosophy major. But definitely got some interest in it after the fact. Harbinger of imminent death. If you do a video on how thinking works, you simply must do a follow-up How Thinking Works Massachusetts edition. That's a challenge. Maybe we'll have to use that as like the examples. We'll talk about the proof tables. This is part of the symbolic logic and just like, yeah, how to analyze different propositions, different claims for truth or not truth. And one of the ways you do that is you go through like all the different permutations of like, if this is true, does that have to be true? Or could this be false if that's true? And all this stuff like that. We can make up a special table for, but when you're in Massachusetts, even if you weren't hit by a car, she might still be guilty of hitting you with a car. That's a good idea. Thank you. Thank you for that. I might just take you up on that. Kathy, your realtor in Jersey. I am 15 minutes behind. This is one of the clearest explanations of a nuance in the law. I almost hope the attorney is compelled so we get more insight. I do too. Like I said, I think it's cleaner. It's much cleaner and it's fairer. You know, it makes sure that to the extent there is a substantive complaint here, that it gets a fair shot at court, that we aren't dismissing it because it's inartfully worded or, you know, whatever, or just we presume it lacks merit because it's a pro se handwritten petition, you know, those kinds of assumptions. I do want to give it a fair shake. And because I don't know what the facts are, I look dimly on the prospects, but I don't know. And I don't know that we will know unless he gets a lawyer who can call up Ann Taylor and be like, so what's the deal here? So what happened? Because I'm telling you, if he gets a counsel and then this petition gets withdrawn, I'm telling you exactly right now what was said on that phone call. It's just, I don't know. I think I agree. I think it would be helpful. Kathy, your realtor in Jersey, can Richard Allen make this claim? Richard Allen is not even at the point yet of having to think about post-conviction relief because his Judgment and sentence isn't final yet because his appeal is still ongoing. And then depending on whatever happens with his appeal, if his appeal got sent back and he gets a new trial, then, you know, we're in a whole new ball game. If it sent it back for findings to support, you know, say the Franks, or not the Franks, but we're getting at that point in the stream where I'm starting to lose my words and lose my thoughts. You know, the probable cause warrant affidavit, Delaware. Yeah, it is Franks. It was the other Franks issue though. Just not necessarily the third party suspect ones. But say like the search warrant issue. Okay, we got to remand it for findings, you know, on whether there was material misrepresentation and so on and so forth dealing with the search warrant. It doesn't get final until all of that's done. So, and that can then potentially also be reappealed back up. And the court can be like, yeah, you didn't do it right. Do it again. And so your sentence is still not final because you still have this like continuous appeal and necessary action following from it. So anyway, I offer all that to say that he doesn't have to nail himself down to anything until really the timeline, the deadline starts to run, you know, then you need to be prepared to get your issues down. But it's gonna depend on what's there that we don't already know. You know, that's kind of the challenge with predicting post-conviction relief and ineffective assistance, is because the fact that things didn't happen is why we don't have a record of it to know already, you know? And so, but it didn't happen, so you don't know what it is. And this is the kind of circle trap you get stuck in with ineffective assistance. My attorney didn't investigate something, therefore I don't know what it was, therefore I can't show that it would have affected my trial. I have to have some other way to figure out what it would be. And sometimes you can find that out, but sometimes you can't. So it's just potentially very tricky. I do know that Indiana does have a similar statute like we saw here in Idaho, where they can petition for DNA testing. There's, you know, new methods and stuff available, potentially exculpatory. That gets treated as a post-conviction petition in Indiana, is my understanding. I think Michael Osbrook told me that. So it would have to be like in conjunction with any other issues he would be raising. But that's just an example of something that I see kind of on the horizon based on what we already know about the evidence. There's a lot of untested DNA there that they're like, no, it's too degraded. That's what we have next gen whole genome sequencing for. It's a lot better at, there's just a lot better techniques for processing this kind of, because you can get so much more information from a limited sample that you can't get with the STR analysis. And we already know that, you know, defense didn't do that testing. As I recall, defense asked for a DNA expert and was denied. So things like that are kind of always on the horizon. But in terms of like, is there other stuff that the defense should have investigated but didn't? Maybe. We don't necessarily know what we don't know. And so what is it? What would they have found out if they had investigated it? That's the part that can be kind of tricky to ascertain. So it's definitely feasible if he's got the facts. We're just not in a position at this point to really know what his facts are. RVing, keep it rolling. Yeah, keep it rolling. I'm glad I caught you live. I value your expertise. Thanks. I'm glad you caught us live too. I appreciate that very much. Brune, not saying this is the same, but the Marilyn Mulero case is interesting. All right, I'm writing that down because I am not familiar with that at all. Marilyn Mulero. I will check it out. will take your word for it that it is interesting and give it a look. I don't know. I don't know if it's a ineffective assistance or a misrepresentation or something like that. So I will be eager to see what this case is. Well, thank you guys for joining me for yet another extended, hopefully not too rambling exposition on a very, very technical and complicated area of the law, the post-conviction petition. And so hopefully I was able to achieve my goal here of giving you the big picture of the process and the standards and the decision trees and so forth that go into this, and then help you walk through this actual petition, the specific allegations that are made and how those are likely to compare, flesh out under the standard that we get. It's a lot of ifs, a lot of if this, then this scenario, because it really does just depend. A lot depends on what the state does at this point. A lot depends on, of course, if he gets the counsel, what counsel does. But yeah, I'm going to continue to watch it. At this point, the case is live again, then it's caught my interest again. When it's not a case, I don't really care. I don't really care about some book, that's out there, because it doesn't matter. It's not part of the court case. I'm not any better at anybody else at like knowing what is true and what isn't true. I just have maybe a systematic understanding of how we make those decisions that I would love to share with you guys. So, read a book. I don't really have anything to add to whether that's a good source of information, helpful, whatever, or not. So I tend to not do that. I stay in my lane. My lane is court cases. That's where I have something to add, I think. But here we are back with a court case. So yeah, now this is opened potentially some more doors. So we got to see where it leads. I'd say at this point, that's really my $1 million question with Hippler, with Judge Hippler, is do you just brush this off with contempt? Nothing to do here. Summary, not give it another thought. Or do you think to yourself, you know what? He thinks he wants a hearing. Well, let him have it. See how that works out for him. I really kind of do see either being possible. And yeah, I think whether we get counsel appointed to it or not, maybe at least an indication, an inkling of a leaning towards how he might be thinking about that. So I'll keep my eyes on it. Oh, guys, like I already said, like a million things right now. I have a whole bunch queued up on the Substack. I have been working through my fact check, my Alice Evans fact check. It's massive. It's so big, there's going to be 2 of them. So a lot to get through with that, but I am working on trying to get that tidied up and out. And then I do have all the exhibits as well. I've got them scanned, so I will be creating the archive on the Substack to hold those exhibits. We've got, like I said, Tyler Robinson stuff is coming up. I have all these collateral ideas about the how we think. Other stuff is going on. Oh, there's a whole thing in the Nick Reiner case that I want to follow up on. I'm not gonna go too far down that road right now, but yeah, gosh, guys, like big plate. So assuming I'm able to work through it all and don't just like lose my mind and throw up my hands and decide to go to the mountains instead. I do expect to have quite a bit of stuff coming out in the next few weeks. So a lot of it will be Substack focused. So do keep an eye on that if you are interested. Otherwise, yeah, looking forward to the Tyler Robinson brief. if I can get my thoughts organized for the How Thinking Works series that I'm kind of formulating in my mind, then that might be coming up soon. I still have Jim Martin's appeal, guys. I finally got through the sentencing. We got that done. But that's not over. That's not the end. We got a bonus episode because he appealed, and so we'll be taking a look at that. So those are some things to look forward to on YouTube when that happens. Otherwise, just kind of waiting for the hearings and stuff like that. Nothing real super on the horizon that I can think of. I am not following the Lindsay Clancy. Not going to do it. Not going to do it. It would not be good for me at this point in my life. It's just too much one of those cases where there's no winning, there's no justice, no matter what happens with the case. There is nothing good about what is happening there. And just already what I'm hearing about how it's going is exactly why I wanted nothing to do with it in the first place, just for my own mental health. Better to stay away from that one. So don't be looking for me to pipe up on that. But there are some other cases coming up in the meantime. I know Courtney Clenny is going back to court soon, but I don't think it's not the trial yet. I'm not going to cover the hearing live. Probably won't cover it at all, honestly. Really haven't done much on that case yet because I have kind of been waiting for the trial. We're still waiting for rulings in Mickey Steins' case so that, we kind of can see how that one is going to go forward. And what else do we have? Yeah, nothing that I can think of on the real close horizon. We're about a month away from Luigi getting going, but that one's going to be tricky because of the no cameras. I'm still waiting. I mean, I got my fingers crossed that hopefully soon we're going to see some charges in the Miranda's rescue case. Talked about that one on X a little bit and on Substack. It's just appalling animal abuse and fraud case. It's a very slow investigation just because of the nature of what they have to prove. We're waiting for movement on Afroman's appeal. New case that just came across my radar that I may be taking a look at. A case against a guy named Charles Miranda. This happened in Texas last weekend. Appears to be a road rage incident that resulted in a up-and-coming boxer, a young female boxer, was killed, hit by a car on her bicycle and killed. And he has been charged at least with manslaughter. But I'm kind of waiting to see how that one unfolds. But I'm interested in that. If the facts are kind of what they're described to be, then I'm not sure why we wouldn't be looking at murder, intentional. The facts are basically, from what's known, that there's a group of bicycles on the road. The car passes them, passes very close. There's like a foot between them. So the bicyclists like wave and yell, probably nothing polite, but like, the fuck, dude. And his reaction was to stop and put the car in reverse at high speed and back straight into boxer Hannah Rapp and kill her. So that sounds rather like intentional murder to me. A little bit more than manslaughter. I can see manslaughter as a lesser, but not really where I would start with it. Yeah, guys, that's just the big picture where things are at. So that's what I got on my table and what I'm interested in. Keep your eyes open for the Substack. See what comes out there. Otherwise, you know what to do with the YouTube and the getting notified and all that. So that when I do decide I'll go live, you will find out. I will also, by the way, probably do a live about Alice's exhibits after I've gotten kind of everything out and organized and stuff like that, just to like talk it over and see if people have questions and things like that. But also just because it's fun. Oh my lord, the stuff in these exhibits, guys. Ugh. Yeah, looking forward to sharing that. So with that, guys, I want to thank you all. I want to thank the mods, of course, as always. Appreciate you so much and everything that you do here for the channel. Thank you so much for the nice compliment to both my shirt and Heidi's art. I agree, Heidi's art is spectacular. I do like to try to incorporate myself with it as much as possible. So, yeah, call this one a wrap, guys. Appreciate all of you. Thank you. If you are dealing with the smoke, the wildfire smoke, the way that I am, do watch out for your health. Don't force yourself to be out there exposed to unhealthy conditions. I'm struggling a little bit with this because I do like to be outside. I do like to be doing things, but boy, do I not want to be breathing heavy with all of this particulate stuff in the air. Just not good for you. So it's a challenge to kind of make myself stay inside, but that's fine because, like I said, got this pile on my desk to get through. But do try to find the common ground, guys. Look out for yourselves. Take care of your biological needs. You know what they are. Whatever else there may be to this human existence, there is this core of this biology that acts the way it acts and benefits under certain conditions, thrives under some, and does not thrive so much under others. So just be attuned to that. It does tend to overlap with whatever other kind of spiritual or emotional kind of outlook, perspective that you have. Easier to be happy when your body is happy. When your body is not happy, it can really, really bring you down. All right, guys. Thank you again for joining me. Thank you for your support. Thank you for your interest. Thank you for all your questions. Thank you, mods. Thank you, everybody. Appreciate all of you, and I will talk to you soon.